Okay. I'll call City Council meeting of February 19th to order. Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Oh, that was like
Ms. Barfield, roll call.
Mr. Norris?
Here.
Ms. Smith?
here.
Mr. Huja?
Yes.
Ms. Dacus? Here. Ms. Galvin?
Here.
We have a number of announcements, awards, and recognitions. And I'll start with the VSA Poetry Recognition. We welcome Jenny Hollander and company for Region 10 and VSA Art tonight to make a brief presentation.
Good evening. My name is Jenny Thallander, and on behalf of both the Charlottesville Therapeutic Parks and Recreation Department as well as the Region 10 Meadow Creek Center for Adults with Intellectual Disabilities, I'd like to thank the Charlottesville City Council for your financial support of VSA Arts this year. VSA Arts of Charlottesville Albemarle was formed in 2000 as a division of the Virginia VSA Arts, which was formerly known as Very Special Arts. VSA Arts is dedicated to promoting the creative power in people with disabilities. And our local VSA Arts chapter sponsors annual events, including an art exhibit as well as a calendar, a poetry book, both of which you have before you guys this evening, a music recital, a VSA artist-led workshop, the Therapeutic Virginia Festival of the Book, and other special events. In the 2012 budget year, over 8,000 participants, volunteers, instructors, as well as audience members were served by VSA. And this participation represents an increase of over 1,000 members from the year before. The program here is funded by both the Charlottesville and Albemarle Parks and Recreation Departments, as well as community donations, and it's administered by the Charlottesville Parks and Recreation Therapeutic Program. The VSA Arts program is a vibrant part of our city, and it creates a space for those with disabilities in our community to have a creative voice. So again, we just want to thank the City Council for its support and continued funding of our program. And finally, I'd like to introduce Carol Hansen, one of our VSA authors, and she's going to read to y'all an excerpt from her poem Anger, which is found on page 61 of your poetry book.
Yeah.
Okay.
So everybody turn to that page.
61.
Okay. Anger is a feeling you get when things don't go right, and it's deep down within you until it comes up out of you, and you say some mean stuff you really don't mean to say. And that's true, you know. Anger is like a volcano that explodes when somebody makes you mad and you really want to say some mean stuff, but you can't because you love them very much. I've got so much anger inside me, and I wish people would understand that and not pick on anybody who is different.
Thank you very much.
Thank you.
If anybody wants me to sign their book, bring them on.
After the meeting, yes. Thank you.
Thank you.
There's a proclamation. Ms. Sakis, will you please read?
First of all, I would just like to say that I totally relate sometimes, and I really appreciate that. So, and the actual poem is longer, so do look at your book if you have one. I think there may be some in the back as well. This is a proclamation declaring African American History Month. Whereas February has been set aside nationally as a time to remember and learn facts about the contributions of African Americans to America, and whereas during February in particular, we remember the stories of those who have helped to build our nation and our city, and who advanced the cause of freedom and civil rights, and we remember those who helped build our families, places of worship, and communities. And whereas when we examine our nation's history, we discover countless stories that inspire us, stories of the triumph of the human spirit, tragic stories of cruelty rooted in ignorance and bigotry, stories of everyday people rising above their circumstances and the prejudice of others to attain great accomplishments, And whereas, as we celebrate African American History Month, we teach our children and all Americans to rise above brutality and bigotry and to be champions of human dignity and equality. And whereas we rededicate ourselves to affirming the promise of the Declaration of Independence that all men are created equal, that they are endowed by their Creator with certain inalienable rights, and among these are life, liberty, and the pursuit of happiness. Now, therefore, we, the City Council of the City of Charlottesville, Virginia, do hereby celebrate February 2013 as African American History Month in recognition of the struggles and contributions of African Americans, and to make all citizens aware of the significance of the achievements of African Americans in our community and throughout this country, and urge all citizens to mark this month by supporting and encouraging the efforts of all interested groups and organizations. Signed and sealed this 19th day of February 2013.
The companion announcement you had, the
Yes, and to dovetail on that, I'd like to announce the celebration of Black History Month here in Charlottesville will be this next Sunday, February 24th, at Carver Recreation Center. That's in the beautiful new Jefferson School City Center over right on 4th Street. From 2:30 to 4:30, we will celebrate the rich history of some of Charlottesville's past, present, and future with guest speakers, including Mistress of Ceremonies Marcella Robinson from NBC 29. There'll be exhibitors, music, stepping, light refreshments, and door prizes, and this is sponsored by Charlottesville Parks and Recreation and the Dialogue on Race. So that's next Sunday, 2:30, Carver Recreation Center.
next I would like Mr. Norris to read a proclamation, which I think you'll all enjoy. And there's somebody here to receive that.
Yes, Mr. Mayor, City Councilors, I'm very pleased to proclaim the latest version of the Big Read here in Charlottesville. The Big Read kickoff will take place on February 23rd at 2 p.m. at the Free Speech Wall in the downtown mall. The book for this year is The Joy Luck Club by Amy Tan. And I'm going to read a part of a proclamation here. The Big Read 2013, The Joy Luck Club. Whereas the Big Read is designed to restore reading to the center of American culture and provides our citizens with the opportunity to read and discuss a single book within our community. And whereas the Jefferson-Madison Regional Library invites all book lovers to participate in the Big Read that will be held throughout March 2013, during which the library's goal is to encourage all residents of Central Virginia to read and discuss The Joy Luck Club by Amy Tan. And whereas the novel tells the story of new waves of immigrants who are changing and enriching America and have mother-daughter conflicts, and whereas the Big Read is an initiative of the National Endowment for the Arts in partnership with the Institute of Museum and Library Services and Arts Midwest, and is supported by the Art and Jane Hess Fund of the Library Endowment.
It is a cooperative venture in reading. Now, therefore, be it resolved that I, Satyendra Singh Ahuja, Mayor of City of Charlottesville, do hereby proclaim the Big Read during the March 2013 and encourage all residents to read the Joy Luck Club during this time. Sign and seal 19th day. Again, I do want to encourage you all to read the book. I think it's a wonderful book. And here there is a Jackie Lichman here. Too. Would you like to speak?
I can just say that
You have to say it to the microphone for the people at home.
I'll just tell everyone that there are wonderful programs throughout Charlottesville and Albemarle. The website is www.jmrl/bigread, and you can just find out all the things that are happening. Hope we'll see you at some of these events.
Thank you for coming.
I'm hoping there will be mahjong instruction, because when I read that book, I kept wondering how mahjong is actually played.
There are actually two programs that are teaching mahjong. One is going to be Friday, March 15th at the Senior Center at 9 o'clock,
Okay.
and the other is Monday, March 18th at the Gordon Avenue Library at 7 o'clock. And you can learn to play mahjong and also Go, which is a Chinese game.
I know how to play that.
Thank you. Ms. Galvin, do you have an announcement?
Yes, I have two. Treasurer special election. A special election for the office of Charlottesville Treasurer will be held Tuesday, April 2nd, 2013. For more information about registering to vote, the special election, or polling places, please contact the Charlottesville City Voter Registrar's Office at 970-3250. There will be a public meeting on Monday, February 25th, 6 p.m. at City Space, and it's about the McIntyre Park Bike Pedestrian Trail Bridge over the railroad tracks. The City Parks Department is working with RKK Associates to design a trail bridge over the railroad to connect the two sides of McIntyre Park and support the 250 Bypass Commuter Trail Project. City staff will provide information about the project and take comments from the public. For more information, contact Chris Jenzik at 970-3656 or email jenzik@charlottesville.org.
Thank you. Yeah.
Next, well, the Thursday after next, Thursday, February 28th, will be the next Our Town Charlottesville meeting at the Belmont Carlton neighborhood. It'll be at Clark Elementary School from 6 to 8 p.m. There will be dinner provided. I'm hoping there will also be childcare provided. That was something that hadn't been finalized yet. It's a chance for people in the Belmont Carlton neighborhood to come. It's going to be, the entire meeting is public comment, no time limit, within reason. We're hoping that people will come and let us know some of the issues facing the neighborhood or some things that people in the neighborhood really just want us to be aware of.
Thank you. Ms. Smith, do you have any other announcements? Anybody else has any other announcements? If not, we are Ms. Barfield, would you read the consent agenda? Sorry, I skipped something. Sorry. Let me take a break from the usual. We are going to go to matters by the public, but I have been made a request by some citizens that there will be another public hearing on drainage issue, stormwater utility issue. And I wanted to check with my colleagues if they want to do that. We already have had a public hearing on this topic and had discussion at least 2 other meetings. And but if you would like to have another public meeting, I would like to find out from you guys. Is council would like to see another public hearing or not?
I'm a big fan of public input, but I really feel like this is something we've been discussing for 8 years, and there have been various forms of public engagement, so I'm not feeling it particularly compelled to do that. We have public comment tonight as well.
Lady? Ms. Smith?
I'm not inclined to have another public hearing.
We may have been talking about it for 8 years, but I think there's a lot of people in the city that are just finding out about it and just figuring out what the implications are going to be. And so I would, and there's really no rush. This program wouldn't go into effect until January, I believe. So I don't see any reason why we wouldn't want to have.
Except that we need to know how to do the budget. That's the rush.
Right. But I don't see any reason why we wouldn't want to give citizens one more chance to weigh in, particularly those who are just finding out about it.
Ms. Smith?
I have no problem with having another public hearing. I don't know that it necessarily stalls the process. Anyway, it may or it may not, but we won't know. But I'm supportive of it. I'm actually a little surprised we're not having a public hearing on the marijuana ordinance as well. But that's another matter.
Mr. Jones, do you see problems with delaying another meeting?
I mean, I think if we decided to have another public hearing, I think it would have to be at another meeting, and it would be
Yes, of
advertised
course.
as a public hearing. We
Well,
wouldn't
it
do
had
that
to
this
be-
evening.
Not today.
Right.
Okay. Well,
An alternative would
Let
be
me-
to actually have a dedicated time tonight, not
Extended
call it a
public
public.
comment.
Instead of,
think-
That I would support.
I would support that.
Because I think that we have a lot of people here who are here about that issue. But, I think when we talk about a public hearing, today, that's not the only way for the public to reach us. We've received hundreds of emails, so I think people know how to reach us, and we've, I think, read them all and replied, and
And
we're
Mr.
certainly taking those things into consideration.
And also, Mr. Jones, could you please review the notices that were delivered and made clear that there were various opportunities in the past for the public hearing and for weighing in? So
Sure.
that might be helpful to just reiterate that,
And
please.
it's part of our presentation this evening to talk a little bit about that. But we did have public forums back in the fall in which all nonprofits who are considered tax exempt were notified of what was going on with stormwater. We've, of course, this is the 3rd meeting this year that we've had to discuss stormwater. We also met last year, and when council decided to start the process yet again, after we'd gone through this process back in 2008. There have been numerous news stories on it as well. We sent a lot of emails out, thousands of emails that went out. We advertised the public hearing that we had several weeks ago as well. So those are some of the things that we've done to try to advertise
Okay,
this.
so what I'll suggest today is that we will add another half an hour on public comment period. So after the public comment period of half an hour, we will have another half an hour for people who are missed out the chances to say their viewpoint on the issue. They'll have another half an hour. You can come and speak. So I'll give you that time for comments on this topic of. Thank you. Consent agenda, Ms.
Well,
Barfield, will you read?
We still have other public comment, matters by the public.
Yeah.
So we just had,
And I would say let's free up at least one space for somebody to speak on the marijuana issue. I know there's a lot of people here that want to be heard on that issue. So.
Okay. So let's start with public comments. Your list. Oh, that's okay. Louis Martin.
Well, again, if we're going to have a dedicated portion of the meeting for stormwater, I'd say have the people that signed up to speak on stormwater wait until.
Yeah, I think that'll be good.
Oh, that's a good
Is that
idea.
fine?
Yeah.
That
That'll
would
be
be
fair.
good. Thank
And I
you.
would not mind substituting Mr. Fogel on the marijuana issue because he is quite passionate about it and the public hearing is not required, but I'll be happy to hear from him.
Right now?
That'll be fine.
I think the first thing I would comment on why there isn't a public hearing.
It's not required.
That's not a reason why not to have a public hearing.
That's a pretty good reason.
It may not be required a lot of things, but that's not a good reason why not to have a public hearing on an important issue. Mr. Jones just explained all that has been done on the stormwater issue, public hearing, information,
You
and
have
so
3
on,
minutes
that
to-
did not occur here. That's all I have to say about that. With respect to the proposal that's been put before you by the city attorney, I urge you to adamantly and unilaterally reject it. It does nothing. It is a waste of your time and a waste of our time. The question that's before you, and there are other people who I think have a right to speak as well, and if you're going to open it up for the stormwater people to be able to speak, and they should be able to speak, albeit not at a public hearing, you should do for the same for the people who are concerned here. I have a modified proposal that I'm prepared to present to the council, part of which deals with the issue that Ms. Zakos has raised, which is the fact that people would not have access to an attorney if possession of small amounts of marijuana for personal use were limited.
Is that this one?
Oh, I'm sorry. We're limited to a Class 4 misdemeanor, and I have added to this section that the accused has the option to elect to proceed under the state statute, which would then give the accused the opportunity to make that decision if the accused wanted to choose a lawyer and risk the possibility of jail. What we're talking about here essentially is, and principally about second and third offenders, people who might be convicted for a second time of possession of one joint who could go to jail for a year. We have tried unsuccessfully a punitive, retributive, regressive approach to the problem of marijuana use, and it's been unsuccessful. We need not our criminal justice community, not the police who are experts at catching criminals, not the prosecutors who are expert at convincing juries, but our public health community to step forward to deal with the issue that I think we all agree we're concerned about, which is the use of marijuana by young people. I was very disappointed that although the health district commissioner had weighed in on the dangers of marijuana, when I went to look on the site, the website, not a word about marijuana. Not a word about marijuana on the State Department of Health site. So if there's a real concern about the use of marijuana by young people, you think we would be dealing with it as a public health issue, and that the public health officials that we either elect or appoint or respond to would take that cup and deal with it. And I would suggest that all of us ought to be on the public health sector to be trying to do something about this and not abdicate their responsibility to a punitive approach. Some people here feel, apparently, that jail is appropriate. And I would ask those people, if your child were arrested, would you think it appropriate that your child would go to jail? And if so, what will you tell your child as to why you voted to keep jail time on the table if you don't think your own child should go to jail if that's what happened? You may think that this approach hasn't worked. Maybe we should be more punitive. Maybe we should flog people in the public square. Now, you'll say that's barbaric. But let me tell you, putting somebody in a cage for a year without access to anything, with every bit of their life dictated as to when they can eat, what they can eat, how much they can eat, when they get out of their cell, when they can have visitors, when they can see their attorney, when they can have recreation, and so on, with the consequences that they are deprived of their families are deprived of them, of the emotional support and of the financial support that they may provide for their families, and we as the public are deprived of money that's doing nothing. To me, that is a case of modern-day barbarism, no different than flogging people in the public square. We have to keep our focus on the public health issue. We all know the statistics. We should. 5% of the world's population, 25% of the world's prisoners. We should be doing everything we can to get people out of jails and prisons without endangering the public safety. That should be one of our goals. We also know the statistics that the overwhelming number of people who are charged with drug offenses are minorities, principally African Americans. We know also from the Department of Health and Human Services that African Americans do not use illicit drugs in any greater percentage.
Thank you. Mr. Jones of 808 Reeves Street. Mr. Jones? Huh? So this is stormwater, okay. Okay. Jen Downey, 1014 Locust Avenue, sidewalk issue.
I need these. Jen Downey, 1014 Locust Lane. Tonight, I'm here representing Walk Charlottesville, a local pedestrian advocacy group. Walk Charlottesville is thrilled that CVEL's Bike and Ped Coordinator, Amanda Ponce, has included a proposed update to the Standards and Design Manual as a topic tonight in NDS's report to Council. This past September, Walk Charlottesville approached Amanda about the need to update NDS's Standards and Design Manual so that it says clearly that new sidewalks will include, as part of their construction, some form of planting buffers between the sidewalk and the street as a matter of course, unless special circumstances make that undesirable or impossible. She was very receptive and encouraging. Since then, we've supplied the City Engineering Department with examples of how more pedestrian-friendly cities build sidewalks. We've pointed out that for at least 10 years, our city's vision statements have called for a more walkable city, comp plans, bike and ped master plan, the Complete Streets resolution. There's generally no better way to complete a street for pedestrians than by including planting buffers. They're key to increasing the number of people who walk to destinations and increasing the amount of walking done by those people. People don't want to walk on sidewalks that offer no refuge from the sun or feel dangerously close to traffic. Planting buffers solve both of these problems by keeping motor and bike traffic away from sidewalks and providing a place to plant trees for shade. Buffers also act as stormwater catchment areas, tend to slow down traffic. They make ADA-required improvements, such as curb ramps, easier to install. I sent you all an example of this proposed language. Here's some possible new language for the manual adapted from Corvallis, Oregon. Sidewalks shall be located to provide a 6-foot landscape strip on local and local connector streets and a 12-foot landscape strip on collector and arterial streets. This is the most important part. Where inadequate right-of-way exists, a reduction in planting buffer width or omission of the planting buffer may be allowed with prior approval of insert appropriate NDS staff member. Engineers will consider road redesign strategies such as narrowing travel lanes, changing parking patterns, and or reducing the number of lanes on a road before concluding that there is inadequate ROW. We understand that NDS needs flexibility as it copes with the realities of laying sidewalk down on streets of various character and width. This wording would allow NDS to determine in a particular case that a planting buffer width must be reduced or left out as an element, but would make it clear that barring a good reason for not including one would be installed as a matter of course. I would ask Council to please clarify tonight that NDS is indeed ready at this time to update the manual in the manner described, and if not, then when? If this can't be accomplished in the next couple of months, Walk Charlottesville would ask Council to direct NDS to do one of two things: either suspend the planned design and survey work on sidewalks until the manual is updated, or review each sidewalk project currently in the pipeline to see whether it's possible to still include a planting buffer in the plan construction. Okay? Thank you.
Dan Purdy.
Good evening, Council. My name is Dan Purdy, 776 Prospect. I would like to thank you guys for opening up more debate, as I was going to give my time to Virginia Normal, Ed McCain, but as it sounds like he'll have his own time, then I'll go ahead and speak for myself. You guys might know me as Rose's brother. Rose was here quite a bit last year in regards to Occupy and also the decriminalization debate that we had last year. Just wanted to give you an update. She's, painfully going through her drug court, but is scheduled to graduate in May. So thought you guys would like to know that. But in regards to the ordinance you guys are thinking about passing, I would actually encourage you guys to go ahead and pass this law. I realize the other gentleman didn't think it was going to do much, but I applaud any effort that keeps people away from the heavy-handed and inhumane ways that marijuana offenders are treated by the Virginia system that's in place. And if you guys can do what I believe this ordinance is there to do, which is basically to slap a parking ticket on somebody and charge them their monetary fine and pass them on down the road until they're second and other offenses, then I applaud that effort. Just the ways that drug offenders are treated in the state system does seem very heavy-handed, to have to submit to, very probing, privacy invasive drug and alcohol screens and a bunch of addiction meetings that most marijuana users just don't feel connected to. I mean, there's a very different addiction property to marijuana than there is to crack and heroin and alcohol that these meetings are geared towards. And you really feel like a duck out of water, at least I know Rose does, being at these meetings that just don't feel appropriate. And also the whole rigmarole, the guilt involved with the court system for doing something very much akin to drinking a beer or smoking a cigarette. There really should not be this level of stigma and guilt involved with smoking marijuana, and also the criminal records that come with that. So again, if you guys feel like you've figured out a way to circumvent some of the heavy-handedness of the state and just make it a simple monetary offense for the first time around for casual, less than half-ounce users or holders, then I again encourage that. But it also, the biggest reason I encourage that is because it funnels people and therefore encouragement away from this very bad industry. We've built up this big industry of courts and this big industry around everything to do with the piss tests, just everything, every little facet has a job and a budget and just this big thing that's grown around a very, what the gentleman said, to be a much more health-oriented item and something that doesn't need to be criminalized and have this huge government bureaucracy come down and invade people's private lives for, again, something that's much more akin to drinking a beer or smoking a cigarette. Anything else? Yeah, that's about all I wanted to say. And thank you guys for bringing the issue back onto the floor in some semblance again. Thank you.
Thank you. Carol O'Connor, are you speaking on drainage or Belmont Bridge?
Belmont Bridge.
Please come forward.
Yeah, hi, thank you. So I just wanted to make a couple of comments following the meeting, the public meeting in the library last week about the Belmont Bridge and the sheet of comparison between the bridge and the underpass and what was presented as fact at that meeting. And I know I speak for a lot of citizens that people were pretty upset that it wasn't very well vetted and there wasn't a lot of support for where the information came from. There was one project cited as to where the numbers came from for the underpass. And I know a lot of people brought up some very pointed questions about questioning the veracity or at least the complete research. If something's presented as fact, I think the public, at a public meeting by the city, the public expects that it's been researched. And the one project that was brought up
to support a $30 million budget was in Hampton. I specifically asked, I know a lot of people ask pointed questions, I specifically asked the engineer, was it roughly the same as the project that was proposed for the replacement of the Belmont Bridge? And was told in front of everybody, yes, it was. Well, I just wanted to bring up that the the underpass proposed for Belmont is 22 feet deep, whereas the one in Hampton that was cited was 35. Ours is supposed to handle about 15,000 cars. Hampton Road's 42,000. Ours would be roughly 3 lanes wide. There's a 6. So I would like to propose that somehow when we give information to the public, that there's some way to provide more transparency as to how those numbers are brought up and supported. And that if the public is being presented with 2 options, that they be handled even-handedly. I will say that even though I am a supporter of the underpass, because I believe that it really provides an enormous amount of economic development potential. I know as a business consultant dealing with a lot of businesses, there's just not the same cachet to being on the other side of that bridge. I think if the bridge goes away, that really barrier to thinking that as the end of that really high desirability really kind of goes away. So even though I am a proponent of the underpass, and I think that's the option that got short shrift at the meeting, I think even if I were for the bridge, I would be upset that I was getting information that seemed very stilted. So
thank you very much.
Thank you.
Before I move into drainage comments, I'd like to invite at least 1 or 2 more people to talk about marijuana issue. If you're in the audience, you'd like to speak on marijuana issue, this is your chance to come and speak.
Good evening. My name is Ed McCann. I live in Lynchburg, and I'm the executive director, of Virginia NORML, statewide organization working towards repealing marijuana prohibition in Virginia. We represent hundreds of thousands of cannabis users in Virginia. We support this new ordinance, minus the additions made by the city attorney that would do nothing and continue to put people in jail for this, because jail is not the right approach to marijuana use. According to state statistics generated by the Legislative Information System, 19% of first-time offenders are sentenced to jail with a median sentence of 15 days. That may not happen in Charlottesville, but it happens across the state. Albemarle County, in order to protect their children, arrests them. 46 children were arrested in Albemarle County in 2010, including 4 13 to 14-year-olds, 4 15-year-olds, and 11 16-year-olds. If we want to send the message that pot is inappropriate for children, why are we using the police to deliver that message? I thought we enact ordinances to regulate the behavior of adults, not to send messages to children. In Colorado and Washington, Americans are now free to use cannabis without fear of arrest, prosecution, and all the collateral consequences. Parents there now have the opportunity to speak the truth about marijuana to their children and tell them that it is inappropriate to use, just like alcohol, just like tobacco, just like many other adult behaviors. But they can tell them that they won't go to jail for lighting up, just like they won't go to jail for supporting the state-funded alcohol industry. Just because something is legal does not mean it is good for you, and including we, the cannabis consumers of Virginia, recognize that. We understand Charlottesville does not generally jail its citizens for marijuana, but we are one police chief away from continuing to do that. We have seen how this community in Charlottesville and Albemarle County is understanding the uselessness of prosecuting marijuana people in a notable case where it was difficult to seat a jury for people's reluctance to prosecute for this so-called crime. In Colorado and Washington, our brothers and sisters and friends are free from arrest, while Virginians for 15 grams, which is about 15 paper clips worth of marijuana, can face 5 years in prison, including our friend Jordan here. And keep in mind that this ordinance will not give a license to light up to all the children in Charlottesville. It will still saddle them with a criminal record. It will still allow us to take away their driver's licenses. It will still allow us to restrict their financial aid, to restrict them from adopting a child, to restrict them from public housing. These are consequences that murderers and rapists do not face, but marijuana users do. This ordinance still provides you with those harsh consequences for our children. But it's a baby step in the right direction. Thank you.
Thank you.
Also, looking at the proposal that was in
Tell
the
us your
background.
name and address, please.
I'm sorry. It's Jordan McNish, Beasley Lane. That's 2560.
Thank you.
Looking at the ordinance proposal that is in the background materials, I would also urge you to reject it. I think that most of us here realize that most people that go to jail for marijuana may be on their second conviction, and they may have some kind of addiction issues that need to be addressed. But this proposal as written just doesn't really allow for those people to be diverted from the criminal justice system. And I had a statement that I wanted to read a portion of. My understanding of marijuana prohibition has, over the last year, evolved from baffled puzzlement to a realization that it is used to tacitly target minorities. If the war on drugs is colorblind, as drug warriors maintain, why is there such a discrepancy in the people that actually go to jail? Why did Mother Jones report that Virginia's inmate population was 60% black? I believe that my incarceration was a sort of collateral damage in a war waged on people of a disposable racial and socioeconomic status. I've always thought it insane that people could be pulled out of society for smoking marijuana. I don't feel like a dangerous criminal. There's no statistic, argument, or concern that could convince me that I have ever belonged in jail rather than school. Consider the message voting against this proposal will send to children. Is the message you wish to send that you will, at all costs, shelter them from learning to use reason to make wise decisions? Is the message you wish to send that, after protecting them from developing this reason, you will send them to jail if and when they are caught making quote-unquote unwise decisions? Furthermore, should we sacrifice the future of yesterday's children in the name of the generation that will succeed them? At any rate, this is a hypothetical concern, as this proposal does not directly affect children. A state-level change is neither necessary nor forthcoming. The strict penalties that marijuana distribution that are there for it will be untouched. This proposal is a recognition that Charlottesville will be better served by a more sensible policy. Because society recognizes that sending productive people to jail is bad for society, it's very common to issue a slap on the wrist for marijuana possession. This has likely happened to someone you know. However, people of a different socioeconomic status are routinely sent to jail with little public outrage. This is not only a civil liberties issue, it's a civil rights issue. Don't be on the wrong side of history.
Thank you.
Good
You'll be
evening.
the
My
last
name
speaker on
is
this topic. Are you here for speaking marijuana also? Yes. You'll be the last speaker.
Give us your name and address.
Okay. Good evening. My name is Paula Klockner, and I'm here to tell you my story. I know many of you do not think that this change of first-time marijuana offenders not receiving jail time may be a small or insignificant change, but I am here to explain to you how this small change would have made a huge impact in my life. Sorry. I was born in Chile. I came here at the age of 6 when my father was offered a position at an international company in Washington, D.C. I came here with a G4 diplomatic visa and have never been in the United States as an illegal immigrant. I received my green card at the age of 16. I was never in trouble with the law. However, in 2000, while I was in college, I received a misdemeanor possession charge for 0.10 grams of marijuana. After my 6 months unsupervised probation ended, I thought my small brush with the law was over. Little did I know that in 2006, this small incident would change my life completely. After visiting my mother, who now lives in Chile, I was stopped by the Department of Homeland Security upon entering the country. I was stripped of my green card and was put in immediate removal proceedings. In immigration court, any misdemeanor controlled substance charge that has jail time attached to the original charge is considered automatic means for removal, regardless of the outcome after trial. I was detained in jail for 36 days. I can't explain the amount of fear that I felt. I have never been so scared, cold, and felt so helpless than I did those 36 days. Finally, after the DA continued my case 3 times, the immigration judge terminated my case without prejudice to the Department of Homeland Security. I was given my green card and my freedom back, but my story does not end there. The post-traumatic stress of this experience has caused me to develop a stress-related disorder called fibromyalgia. There is no cure for fibromyalgia, and I feel constant pain in all my muscles. I have over $10,000 of medical debt and spend $300 a month on medicine for this condition. So I'm here today to ask you to pass this ordinance. If my charge had been considered a Class 4 misdemeanor without jail time, it would have been considered a crime of moral turpitude. Under immigration laws in 2006, this would not have constituted grounds for removal proceedings, and I would have never been detained. As you can see, this small change would have made a huge difference in my life. So I urge you to pass this ordinance so this does not happen again to someone that might be part of your life.
Thank you, ma'am.
Richard Kennedy, 6009 River Drive, Lorton, Virginia. And my experience is totally opposite of the preceding speaker. It's purely academic. I graduated from college in 1963 without hearing the word marijuana ever mentioned. I went back to grad school in '69, and it was everywhere. And I was an econ major, and I got interested in it as a public policy issue. It was very clear 40 years ago that marijuana is a less dangerous drug than alcohol or tobacco. It was clear 40 years ago. Now the evidence is absolutely overwhelming. We have a drug that kills 0 people a year as far as epidemiological studies can show, versus drugs that kill 440,000 a year for tobacco, 85,000 a year for alcohol. That's not to say that marijuana is a completely harmless drug. It does impair driving, although much less than alcohol, and it does probably increase the risk of certain mental problems. On the other hand, it does not cause any serious disease, cancer, heart disease, etc. Epidemiological studies show no difference in the incidence of these diseases between smokers and non-smokers. We all agree, of course, that kids should not be using it, but having had 2 kids graduate from high school in the last decade, I can tell you it's available to any high school kid who wants it. When they learned that, my friends learned that their friend's father didn't use it but thought it should be legal, they said, hey, we've got to come over and get your dad high. But the first requirement for stopping kids from using is to give them accurate information. That's not enough. You still have to tell them they can't do it, because kids don't make good decisions. But you have to tell them how dangerous the different drugs are. Right now, we're sending them the message that alcohol and tobacco are relatively safe drugs, because the only drug they hear warnings about is marijuana. So any person is logically going to conclude that this other drug, the illegal drug, must be the more dangerous one. And it's just the total reverse of the actual facts. I would also note that over the last 20 years, we've made quite a bit of progress in reducing teen use of both alcohol and tobacco. I think the percent using alcohol is down from, I think, 88 to 70%. Percent smoking cigarettes is down from, I think it's 63 to 40%. Excuse me, 63 to 40%. We actually have a situation now where there are fewer kids smoking tobacco than smoking marijuana in high school. And maybe the other thing I'd like to mention is that right here in Charlottesville, you have 2 of the world's top experts, one on the legal aspects of marijuana, one on the medical aspects. Right? The legal expert is Richard Bonney from the University of Virginia Law School, who in 1970 wrote the definitive history of marijuana legislation, went on to serve as the staff director for the National Commission on Marijuana, which unanimously recommended that it be decriminalized. The other woman is the nurse, Mary Lynn Mathray, who was the key person in getting the Virginia Nurses Association to endorse medical marijuana back in 1994.
Thank you.
Thank you very much.
Now we'll hear for about half an hour concerning drainage issues. Louis Martin.
Mr. Mayor, I have a handout, so please don't start my time until I get that distributed to you. If you all can just take one of each and pass them down.
Sure.
Mr. Mayor, members of council, my name's Louis Martin III. I live at 923 Marshall Street in the city of Charlottesville. I work at 1221 Cedars Court in the city of Charlottesville, and I'm a member and deacon of and at First Baptist Church at 735 Park Street in the city of Charlottesville. My concern today is principally regarding the funding of the stormwater management program. We've discovered that there are two paradigms for funding this. One is the Northern Virginia paradigm, which uses real estate taxes. The other is the Tidewater paradigm, which uses the model that you all are poised to adopt if you adopt this ordinance today. I was initially curious as to why a jurisdiction would select one method over the other. I asked one of you a couple of weeks ago why Northern Virginia had adopted the real estate tax method, and the answer I got was I don't know. Two other members of council, as well as a citizen who served on both the original advisory committee established in 2008 and also on the advisory committee reestablished in 2012, told me that you are selecting the method that you are selecting, the Tidewater method, to use a utility and user fee because that's what the city's consultant recommended. I called the county attorneys in Northern Virginia at the County of Fairfax and Arlington County and also the City of Alexandria and spoke with the assistants there who handle stormwater matters. And I asked them, why did you do it this way? And they said because it's fair and because it's simple.
Mr.
Yes.
Martin, could you get closer to the microphone?
No, I'm sorry. And so if you look at the first handout I gave you, I received this by email today from the assistant county attorney in Arlington, and they give the analysis of their staff member. This was done in 2008, who is the Kristen Ritterwald of Arlington. And if you look at this, you see they considered other funding mechanisms, including establishing a stormwater utility, an approach that had been adopted by roughly 500 communities nationwide. Under this arrangement, you're billed based on impervious services. They said, however, there are substantial costs and the effort necessary to modify the existing water and sewer billing system to accommodate this charge, develop equitable credit and exemption policies, and undertake an extensive public education and outreach initiative, which would render this considerably more difficult to implement than a real estate tax. They also said that a real estate tax is reasonably easy to administer, as it can be included in the real estate bills, and it would not apply to existing tax-exempt properties. I prepared a schedule. If this is a fee, I can't deduct it. The fee range for my house is $72 to $144. If you increase my property tax by 3 cents per hundred, my net cost is $85.92 after you apply my federal income tax deduction. Many other people in Charlottesville itemize their income taxes, and they would, in fact, be able to pay you more money, and you get more user fees this way. I also asked Ms. Ritterwald, what's the percent of the user units, billing units, that the charitable organizations would use? She said 6%. That means 94% of the units are coming from taxable property. We should be able to put that 6% on our shoulders, on my shoulders as a resident, and pay for our charities so that they don't have to use their funds that should otherwise be used for charitable purposes.
Thank you. Mr. Jones.
Good evening. Thank you for allowing us to speak tonight. My name is Ray Jones. I'm a double who, UVA College in 79 and law school in 82, and have a master's in tax from Marshall Wolf School of Law in 1993. I'm a tax attorney with Lewis Martin's firm. I've been here since 1995, but I'm also the pastor of Faith Baptist Church at 808 Reeves Street right here in Charlottesville. I've taken 2 trips to Kenya, Africa, and taken a mission team with a medical team both times. Each time we've treated over 2,000 patients. But as to this meeting, I have not received any notice in my P.O. box at my church or my mailbox. Both are functioning fine. The only way I found out about it was from Lewis Martin notifying me of it. If you took the monthly average of my church, which only runs about 25 to 30 people on a Sunday morning, if you took the monthly average in gross revenues coming in, this $500 or so fee that you're proposing would be 6%. In relationship to Lewis's church, that would mean if you charged him 6%, they would have to ante up about 60 grand. I asked most of my people in the church are on Social Security or governmental assistance. A church is not an income-producing entity. It's all charitable donations. What happens to the couples that we pay their electric bill through the winter, which we've just done, or the couples that we pay their wood through the winter, which we're doing right now, or the van children we bring in from the Habitat House up on Carlton Avenue, or the one child whose father's unemployed and we don't know where his mother is that we bring in a little further up on Carlton Avenue. What about the African immigrants that we help the Lighthouse Baptist Church from Africans from Kenya and other places? Our firm has donated on 10 plus cases over the past several years, all of our fees to help African immigrants. Your tax charge should not come out of the should come out of the 90% income, not the 10% that's a tithe that belongs to the Lord. The 10% is mostly Social Security checks, government checks. It takes care of all these expenses that I've told you about. Your city could not afford to pay for what our church and other churches do. The city should never touch the tithe. Malachi 3 tells us clearly that belongs to the Lord. It's donations. Tax to property owners like me, I welcome your tax on the 90% that I keep, but don't tax the 10% that belongs to the Lord. By the way, many of you may know Doug Eman. He works for the city. His Reeves Park Planning Group is using my church over the next several months at no cost. I would ask you to sincerely consider not taxing God's tithe. Leave the 10% alone and let us do our work for the Lord. Thank you very much. Thank
you. Jim Sneed.
Thank you. My name is Jim Sneed. I live at 1570 Old Ballard Road, but I represent 500 Park Street First Presbyterian Church. I'm an elder at that church and a trustee of the real estate. I want to thank you for giving me the opportunity to speak tonight and ask that you prayerfully consider what I have to say. First, while we're here, I think there's a couple of reasons. Churches are tax exempt. One is the church versus state, to keep the state and the government from interfering with the church. But I think the more important reason is that we provide services to the public that you can't provide. And we're very efficient at what we do. Donations of time, talent, and treasure allow us to do for $1, which would probably cost you $5 to do the same. I came up with a list of over 20 of the churches and looked at your GIS site. And there was over $30,000 of potential payments to the stormwater utility each year. If what we do were to fall on the backs of government, that $30,000 is significantly more, $100,000, $500,000. As I made reference on Sunday, when you take the assets of the church, you affect the hungry, the homeless, the addicted, and the underprivileged in general. I might add that while I was here in December, and those in attendance found out that I was from Presbyterian Church, they were very quick to thank me for our efforts with Pancham. Knowing the financial impact the city owes it to the churches to make sure they were fully aware about what was to happen. And in some of your documentation, you mentioned notification efforts, but I'm telling you they were not enough. The proof of this came on November the 14th. City manager sent out a letter, this after some media coverage, asking interested parties to a special information session to to be held between 12:30 and 2:30 on November the 27th, Thanksgiving, on Avon Street. Acting on the behalf of the church and as the chairman of the property committee, I went with another member. I believe Reverend Bates was there, Ms. Rittenvold, Ms. Haggerty, and we were the only people at the meeting. We realized that other churches were about to be blindsided and reported that back to our session. You owed them more than was given. And once effectively notified, you began to see the reaction. The document that we were given on the 27th from your consultant mentioned two ways to pay for this: utility fee and property taxes. It lacked two documents that were in your council package in December. One of them was a PowerPoint page used when the consultant sold the idea to you and said that the reasons for using utility as a way of funding instead of property taxes were all developed properties contribute regardless of tax status, and mentioned it would be a fee, much like natural gas, sewage, water, and other utilities. Related to this was the exhibit showing how other municipalities handled funding. Since stormwater could not be measured like electricity, water, natural gas, 43% of the Phase 1 permits chose increases in property taxes. Council really hasn't been as transparent as you'd like to be on these options. The consultant earned their fees, and decisions were made by council, I think, long ago. Your decision, 2 seconds, to form a utility instead of existing methods is impossible to undo and will put undue financial pressure on the churches. I would ask on behalf of Presbyterian Church, First Presbyterian, council allow for additional public input before any action is taken. Thank you.
Major Johnson.
Alan Johnson, live at 2605 Hunting Road, here to represent the Salvation Army in this. I too received the mail for our church, our social service agency, and I do not remember seeing an invitation to come. So if it was there, I overlooked it, but I do not believe it was there. Salvation Army has been serving the citizens of this city for over 100 years this year, and we are, but this new stormwater fee is definitely going to have an adverse effect on our services. The things we do are all charity-based, supported by the people of our community. 57,000 people received meals at our facility last year, many of them provided by local individuals, community service organizations, and such. 28,000 individual nights of lodgings was done there on our facility. Along with that, people were assisted with many, many other social service needs. The individual estimate for us is about $2,600 to start with, and it's going to grow a little bit, and on the properties that we use for our services. It may not seem a lot to many, but the Salvation Army, like many other charities, this is supported by donor dollars, and this would mean we're going to have to go back to our donors or look at cutting services to pay these fees. When it comes to the effect, these things, we have to make the obligation. I mean, if we get a bill, we have to pay that bill, so it will be met. But we will use dollars that would otherwise be used to support the programs that are helping people in our community. Just to give you an idea of that level of service, that level of resource needed, 6 or 8 of my kettles at Christmas for one day will have to be committed to pay that $2,600 fee. And instead of going to the community and the residents that we have in our community that need help. Also, even the residents of our residential facilities will be affected, when they look for affordable housing, because even tenant owners and things will increase their fees for their rents and things to match these things. I am in a different situation, both at a social service agency, but I'm also a pastor of a church. And that church reaches out to individuals, at-risk adults and youth in our community. And we do those things through our charitable dollars, helping people with programs so that they learn to make right decisions in their lives and to help them to be able to make something better of their lives. What do I do if I run short of my budget? Am I going to cut those midweek programs to the youth that are teaching them character building programs and teaching them to be good citizens in our community? No, by no means. We will come up with money somewhere to do that, but it is important. Even some of our taxpayers that will receive these fees, they are already on fixed incomes. They are already living below what other people are doing. And another thing of that, their expenses go up, cost of living goes up, and by no means is their financial ability to meet those things going up as fast. Go to the gas station, buy gas today, you realize it just went up. Please help with the nonprofits and churches to help us to be able to do what we need to do, and because these fees will have an adverse effect on our community. Thank you for what you do. Appreciate it.
Coley from 515 Rockland Avenue. William Coley.
Good evening. My name is Master Coley from 515 Raglan Avenue. I'm a resettled refugee from Liberia, West Africa. I'm privileged and grateful to God that I became a member of First Baptist Church. First Baptist Church has been very much helpful to my family. I have 4 kids, younger kids, and First Baptist Church has been helping us with financial needs. So in view of this, when we were told that now the city is going to be charging non-profit organizations such as the church, we know that is going to really affect us. Having all my 4 kids, and they have to go for other activities like camping and so forth. So in view of this, we are kind of asking you, my family and myself, to reconsider so that you will consider to give up these non-profit organizations such as the church that has been catering to refugees that were brought in by the International Rescue Committee. Thank you very much.
Thank you very much. Robbie Savage.
Well, I suspect I'm going to be one of those that's not going to be clapped for. My name is Robbie Savage. I'm the executive director of the Rivanna Conservation Society. I've been a nonprofit manager or an employee for more than 40 years, and I certainly understand the issues that are being raised. However, I'm speaking tonight on not only behalf of Rivanna Conservation Society, but the Southern Environmental Law Center, the Center for Watershed Protection, the Sierra Club of the Piedmont, the League of Women Voters, the Nature Conservancy, the James River Association, and the Chesapeake Bay Foundation. All these groups are nonprofit organizations, and we all support the stormwater utility program and proposal that you have before you tonight. We believe that it's the most fair and the most equitable of the various alternatives that was considered by the advisory committee. I also speak as a former member of the Stewardship of Creation Committee of the state of Virginia. This group works with churches throughout the Commonwealth for the care and protection of our God-given environment. Our schools, our government buildings, our shopping centers, and yes, houses of worship have or may have extensive parking lots, and these lots are often, if not always, made of impervious surfaces. So that when it rains, the pollution from our cars, the oil, the gas, the brake fluid, the sand that we put to melt our snow runs off and into our stormwater systems. From there, it runs into the Rivanna River, going to the James River, and ultimately to the Chesapeake Bay. Now, that wouldn't be as much of a problem if we had a first-class stormwater system. But the underground system that carries our rainwater, in many cases, is more than 100 years old. These pipes have been neglected, decisions have been delayed, year after year, decade after decade. It is time, if we are going to call ourselves a first-class city, to have the underground as first class as the above ground. As nonprofit organizations, we are used to being tax exempt, And again, I understand the points that Bear made. At the same time, we know that stormwater is no respecter of for-profit or nonprofit boundaries. The city has a huge pollution problem. Stormwater is fouling our waterways, and the city council has delayed action for years. Water is the source of all life, and we have a personal, moral, and spiritual obligation to protect it. We urge your approval of this proposal.
Thank
No clapping.
Dan McBride.
Good evening. My name is Dan McBride. I'm a county resident, but I'm a 28-year member of First Baptist Church and a 7-year employee of the same. My first career was as a textile engineer, so I know how to calculate the return on investment for projects. If this ordinance passes as written, I'll have some challenges at First Baptist Church. But let me say that my main point is this. What I know about the ordinance that has jumped out to me and concerns me immeasurably beyond a tax-exempt entity being considered necessary to fund this revenue to the city is the portion where a 40% maximum waiver has been decided by someone as a response to a landowner making improvements that supposedly reduce the amount of storm water that the city systems have to handle. Now, personally, 40%, a cap on that doesn't provide any incentive to me to make improvements. Secondly, it doesn't recognize or appreciate the fact that many have already done some things. Now, we're unique. We have a retention pond, a dry retention pond in the back of our property where over 90% of our water is captured. I don't know how efficient it is at evaporation and perking. That's something we need to learn. But we already capture 90%, and so you tell us that 40% is all we can reward you with a waiver. That's a little bit less than encouraging to me. So the other thing I wanted to say is that we just had a member of our church who does this kind of work give us a budget estimate of what it would cost to convert our silt pond, that we call it, into a, what's that nice word I want, that technical word, that biofilter facility. We're talking about $25,000 to do that. And with the 40% credit on our proposed fee, we're talking 10, 12, 14-year return on investment. That doesn't make a lot of encouragement. I mean, that doesn't incentivize me to do that or to push for that. But if that cap were raised to 80%, 90%, now we cut in half the years required for us to recoup the financial investment. Sure, we're concerned about stewardship, and we're concerned about those kind of things, but still it comes down to economic reality, and I want to leave you why now is the worst time ever regarding economics for us as a nonprofit. I can't speak for the others, but I expect most of them perhaps would have the same story. Since 2008, we've had to react to severe economic conditions, as many people have, but it's caused us to reduce our operating budget by 38%. It's put us now at a place where any new added expense will pose severe hardship. Something will have to go. We'll have to cease funding something. So I beg you to please leave the churches and tax-exempt folks alone just for a little while longer and test us on our stewardship. Test me on whether or not our church will try to make improvements, because we will. Thank you.
Thank you. Someone named Geoff from Love Inc.
My name is Jeff Krasek, and I'm a county resident, but I'm representing Love Inc. My name is Jeff Krasek. You probably don't know me. I am the chair for the board of directors for the nonprofit Love Inc., and you probably don't know that either. If you work for the city for the needy, you know us. If you work for a nonprofit for the needy, you know us. If you work in a church and address the needy, you know us. In the impervious landscape that represents the nonprofits, the government organizations, and the churches, Love Inc. volunteers are the hands that catch those that don't get caught. Beyond the churches, beyond the nonprofits, we catch it. We catch the missing people. For those missing their sight, we deliver food to them. For those missing legs, we build ramps for them. For those who get Section 8 housing without furniture, we collect it, deliver it, and set it up for them. If someone is missing human contact, we provide the ear to listen, the shoulder to cry on, and the arms to comfort. We coordinate the necessities of life, actually living in a world where there is nothing that they have. Sorry, I forgot to bring my glasses. Last year, we answered over 5,000 cases. In the past 4 years, that caseload has doubled. In the past 10 years, it's gone 10 times higher. Our budget is substantially the same. We do all of this on a shoestring budget. What you paid your consultant was significantly more than our entire budget. And we do this with the support of churches. 30% of our funding comes from the people that have been talking to you. Perhaps City Council can figure out how to count raindrops and who they are owned by. But I can tell you right now the impact that you have today. In the future, theoretically, this may have an impact. But I can tell you the impact right now. And if you want to see it, come to Love Inc. I'll introduce you to the 200 or 300 people that we see every day that have nothing. This law may make you feel better if you impose it, but it's hurting the very people you need to help. Thank you very much.
Bruce Wardell.
Each of these are just considered copies.
My name is Bruce Wardell, and I would like to address the issues surrounding the new stormwater management ordinance you're considering. I will focus on its relationship with the community of nonprofit organizations in Charlottesville. I believe there's a deep and a fundamental issue at stake in this. The issue has been articulated in this manner. All of these entities will use the infrastructure, therefore all of these entities should participate in sharing the cost. And on the level of payment for service, this makes perfect sense. But we need to understand that this is the small picture. Here is what I believe is the larger picture. Even if we look at this issue entirely within the framework of everyone uses it, so everyone should pay for it, this thinking fails to understand the larger and enormously important issues that create the nature of our civic community. There are many things our government can and should do, and yet there are many things that our community does better on its own. And it is this symbiotic relationship between these two spheres that creates the fabric and character and what makes our community in Charlottesville great. The manner in which this ordinance will be applied undermines and damages this relationship. By applying the fees homogeneously across the board, it fails to understand that every time a meal is served to someone who can't afford it, every time a child comes to the Westminster Child Care Center, the Molly Mickey Child Care Center, the First Presbyterian Church Child Care Center, the Temple Beth Israel Preschool, anytime a family spends a morning at Upward Basketball, anytime a loved one is cared for at hospice, anytime someone donates clothing, is tutored, anytime a student at Clark Elementary is tutored at Christ Community Church, every time someone sings in a choir or builds a sukkah along Jefferson Street, our community is using and benefiting from those facilities without cost to city government. In many ways, the community benefits in many ways that government cannot do by weaving our community more tightly and more integrally together. A more strongly woven together community requires less service and enormously reduces the cost of providing government services to our city community. Our civic agreement has, for 2.5 centuries, considered that government returns the favor by providing infrastructure, public safety, and representation, allowing those organizations to focus their limited resources on the mission rather than on fees and taxes. By imposing these fees, the city will diminish that civic agreement into one that is simply the trading of goods for services. You're using our stuff, and you need to pay for it. That is a very small story. One of the things I love about Charlottesville is that we don't succumb to the temptation to think small. We understand what the big picture is. We understand the nature of our community and what makes it so great. We have been better than this in the past. And I know that each of you counselors think more deeply and wisely than the underlying thinking of this ordinance, that this ordinance currently reflects, and in the way that it will be administered. I would encourage the council to not adopt the ordinance until it can be changed to fairly and justly reflect the value and civic resources that nonprofits and churches provide to the city. There should be a mechanism where these organizations can continue to provide their services, fulfill their calling, unencumbered by the fee, or tax, if you will, currently anticipated. I'd like one more distinction, and that is, under none of these recommendations are any of the churches thinking that they would be exempt from the environmental requirements of developing their property. That's a separate issue than the way the fees are administered across the board. So they're not saying that they won't meet the environmental requirements that characterize or that create our water quality, but it's the way the fees are administered. Thank you.
All the people who have signed up for speaking, is there anybody who would like to speak, which is new point to add? I'll add 2 more people. Please come on.
My name is Richard Lloyd, and I live in the county. And I'd like to talk tonight, but I won't, I'd like to see a floodplain flood, like they did in the days of Jefferson. I'd like to see the beneficial sediments reach the Chesapeake Bay, which they don't. But let's talk about fair and equitable. Let's talk about a house that may be valued at $400 a square foot. It's 2-story. It's 3,000 square foot for talking purposes, and it has a slate roof and a 1,500 square foot slate roof. And then let's go down and find another house, maybe in the Woolen Mills. That's single story. It's got a 1,500 square foot roof. It has substandard electric, it has substandard plumbing, it has substandard everything. It's valued at maybe $120,000. And that house at $400 a square foot is $1.2 million. But you're treating them both the same. You're treating the poor people the same rate that you're treating some very wealthy people. It's just not fair. It's not equitable. And then when you look at commercial buildings that are worth $10, $20 million, and they have a roof, and you're charging them the same rate that you're charging the guy in Woolen Mills, this doesn't make sense. You've heard all the churches talk about taking care of the poor. Their job is going to get a little more challenged, and their resources are going to get a little bit diminished. And I just think that somebody ought to sit down and think through the difference between taxing somebody on their assessed value versus somebody that's going to issue a fee, albeit a tax, based upon the square feet of the roof that they've put over their head. It's just not a fair assessment. Let the tax system, let the tax assessors take this tax and administer it, apportion it, like they do every other service in the city. Thank you.
Thank you. You are the last 2 speakers.
Good evening, councillors. My name is Vera Mason, and I live on Lexington Avenue in the city. I am opposed to non-profit organisations being required to pay hundreds of dollars in new taxes for stormwater runoff projects. These non-profits provide valuable services to our citizens And if you agree to this extra high tax, then these valuable services may be cut or eliminated altogether. If that happens, I believe these citizens will look to City Hall for help. I would like to speak specifically about First Baptist Church on Park Street and some of the ways it serves our neediest community members. First, the soup kitchen where we serve our poor and homeless citizens provides much more than soup every week. Our citizens receive an entree, vegetables, green salad, fruit salad, rolls, desserts, and drinks. In addition, there is extra food they can take with them. Besides food, there are racks of clothes, books, and toiletries for them. Before the meal, a word of encouragement is shared from the Bible, and during the meal, they listen to music and songs, plus we fellowship with them. Second, housing. During the cold winter months, First Baptist takes a turn, along with other churches, in housing homeless people. But once again, we provide far more than just a bed and shelter. Our clients receive breakfast, lunch, and dinner for a week, showers, haircuts, television, music, games, fellowship, and they can have their clothes washed and dried. In addition to the soup kitchen and housing, First Baptist supports groups like the Pregnancy Center, Love in the Name of Christ, Parcham, and the Good News Jail and Prison Ministry. Apart from the church as a body, its individual members and friends, one, supply new clothes for babies and children, which are distributed through social services. Two, provide Christmas gifts for senior citizens in adult facilities and needy families. For the families, that includes toys, clothes, and games for the children, and clothes and gift cards to adults. Food is given to the needy families. Three, friends and members of the church support the Pregnancy Center, Parcham, the Good News Jail and Prison Ministry, and Love in the Name of Christ, also known as Loving. So to sum up, whether it's the church as a body or individuals serving privately, a high tax will deplete resources and consequently reduce or eliminate the services that First Baptist Church provides. Thank you for listening.
Thank you. The last speaker for this
John
session.
Hayden. According to Ms. Zakos, the fee is fair for everyone to pay their part. So in that context, since churches pay none or reduce taxes, I say let them pay their fair share. However, by the same analogy, let's look at others in this town. People who live in public housing here in complexes with lots of asphalt and runoff. They get free or greatly reduced rent, utilities, and other things, so they should be able to pay their fair share. What about those who live in less expensive houses or make less money? Their properties produce the same amount of runoff. Just because they make less money than others doesn't mean they shouldn't pay their fair share. So you really don't mean it when you say everyone should pay their fair share, because these are the people you advocate should pay less or nothing. How fair is that? If your goal was to confuse the taxpayer to point out to the point where they just throw up their hands and pay it, I think for many you've succeeded. Either make everyone pay this tax or no one pay this tax. After all, quote, the fee is fair for everyone to pay their part. That means everyone.
Thank you.
That was sarcasm.
This is the end of the comment period at this time, and there will be time again at the end of the meeting, and people who want to stay and speak at the end of the meeting, they're welcome to do so. Opportunity for council people to respond.
Do we want to respond to those specifically, or just during the conversation, or to the?
If you will, up to you guys. got here at 6:45, asked to sign up to speak. I was told I couldn't because 12 had already signed up. At least 40 or 50 people have already spoken. Couldn't I get a voice? After the meeting, after the end of the meeting, you're welcome to speak. Thanks.
I think everything that had public comment we'll be discussing separately, so I'm ready to not make any specific comments because I have plans for later.
I just have
Ms. Keller?
there was Ms. O'Connor about the Belmont Bridge.
Oh, yeah.
We have been really concerned about the process, and both from the perspective of the Place Design Task Force has submitted a request to meet with City Manager and Mr. Tolbert. We are well aware that there has been some confusion, and just want to assure the public that we want to make sure that we are presenting the material fairly and even-handedly. So your point is well taken. And then Ms. Downey about sidewalks, there was a level of detail in that I don't think we're going to be able to get into tonight. Perhaps we will, but I will leave it for that discussion later on in the evening.
Yeah, about the Belmont Bridge, I also just wanted to mention that there was a statement made at that meeting. I came to that meeting and I shared the frustration that you expressed, but there was a statement that the decision of bringing it down to one model of the Belmont Bridge would be completed within the month. And since we're the ones who do that, I don't think that's going to happen. So I think that it does need a fair amount more vetting before we get to that point.
Okay, from this side, Mr. Norris.
I was going to say the same thing that Ms. Galvin said about the Beaumont Bridge, so thank you for bringing that up. And I just wanted to correct Mr. Hayden when you said that there are residents of, I don't know if this is on there.
I'm not sure if these are on.
Residents of, thank you, public housing who are getting by on free rent. There's not a single resident in Charlottesville Public Housing who doesn't pay rent. So.
Ms. Smith?
I'd certainly like to clarify.
Please, you had your chance, please.
No, not now.
Say something about my remarks, and I have facts.
You need to wait now. You had your chance.
I'm going to
Okay.
reserve my comments for the agenda items.
I'm going to reserve my comments also for the items as we discuss. I appreciate all of you coming to speak, and if you like to stay here, you are welcome to stay here. Otherwise, if you want to leave, this may be break time to leave. Thank you. Would you, Paige, read the consent agenda?
Item A, minutes for February 4th. Item B, an appropriation contribution for urban forest improvements and invasive species removal in Riverview Park, $4,000, second of two readings. Item C, an appropriation contribution from the American Heritage Foundation for the Charlottesville Fire Department Wellness and Fitness Program, $5,000, second of two readings. Item D, an appropriation of Visitors Bureau fund balance, $100,000, second of two readings. Item E, an appropriation Route 250 bypass interchange at McIntyre Road, second of two readings. Item F, an appropriation to Albemarle County reimbursement for the Fire Protection Assessments Project, $8,241.78, first of two readings. Item G, an appropriation disproportionate minority contact in juvenile justice, $55,556, first of two readings. Item H, a resolution West Main Streetscape Improvements, $350,000 fund transfer, first of one reading. Item I, a resolution zoning text initiation parking lots and garages, first of one reading. Item J, an ordinance emergency communications center cost allocation agreement between city and county, second of two readings.
At the request of one of the council persons, we're going to move West Main Street streetscape improvement after the storm water utility. So other than that, is there anybody else who would like to move any other item from agenda, consent agenda? If not, would somebody make a motion to approve?
I so move.
Is there a second?
Second.
All those in vote?
Mr. Hooja, I just want to note for the record, I'm voting for all items except for item E, appropriation for the 250 bypass.
Okay. Next item on the agenda is classifying marijuana possession as a class 4 misdemeanor. Who's going to make a staff report?
Mr. Brown will be ruled.
Mr. Brown?
Mr. Mayor, members of council, in your
materials tonight is a proposed ordinance which makes the unlawful possession of marijuana a Class 4 misdemeanor. This is offered tonight on first reading. The city does not currently have an ordinance that addresses marijuana possession. Currently, prosecutions are conducted under state law. Under state law, an initial conviction for unlawful simple possession, I'll use the term simple possession to distinguish it from possession with intent to distribute marijuana. Under state law, it's punishable by confinement in jail for not more than 30 days or a fine of not more than $500 or both. A second or subsequent conviction under state law is punishable as a Class 1 misdemeanor. There's also a statutory procedure at Virginia for, under state law, for first-time offenders to obtain a dismissal of the charge without an adjudication of guilt. In a prosecution under the state law, the judge, without entering a judgment of guilt and with the consent of the accused, may defer further proceedings and place the accused on probation with terms and conditions, and if those terms and conditions are met, the court dismisses the charge. The ordinance that you have, as you have directed, makes an initial charge punishable as a Class 4 misdemeanor, which means a fine of not more than $250. It also provides, and this was my addition and mine alone, that any person upon a second or subsequent conviction is guilty of a Class 1 misdemeanor. And that was an attempt to make it consistent with state law. State law explicitly says that ordinances of this city and any other locality shall not be inconsistent with the Constitution, federal law, or state law. There are a couple of questions which I think are raised by this ordinance, and as I say, we haven't done this before, so I'm not sure I can provide you with a definitive answer. We have included a provision, and this is paragraph F of the ordinance, that incorporates by reference the pre-conviction probation conditions and terms that is found under state law. Generally, a court does not take a criminal prosecution under advisement without an adjudication unless there is specific authorization to do that. What I cannot, and I've discussed this with our Commonwealth's attorney, and I'm appreciative of the time and wisdom he has shared with me on this. What's not clear is whether that would be acknowledged under a local ordinance. One of the consequences of being charged under state law, regardless of whether there's a conviction or a deferral, is a suspension of the driver's license. Again, it's not clear to me or the common, and if you'll allow me to speak for the Commonwealth's attorney on this one point, whether there is authority for the issuance of a restricted license for someone charged under a local ordinance. You have, I guess now, two versions that have been provided to you by Mr. Fogel. The first deletes the sentence from my ordinance, which makes a second or subsequent conviction a Class 1 misdemeanor under Mr. Fogel's version. And I know he said that it's primarily for second and third offenses, and in practice that may be. It is not so limited on its face. Under his ordinance, any conviction is punishable as a Class 4 misdemeanor. And in the version that was handed out tonight, and I would defer to the Commonwealth's attorney on this point, I'm not sure I've seen a criminal statute before that gives the accused the option of choosing which law he is prosecuted under. But the version handed out tonight says, in a prosecution under this section, meaning the proposed city ordinance, the accused may elect to proceed instead under the provisions of the state code. And the reason that was inserted is that for indigent defendants, the constitutional right to court-appointed legal counsel applies when there is a possibility of incarceration. Under this ordinance, there would not be, and therefore there would be no Sixth Amendment right to court-appointed counsel as there is under state law.
Mr. Brown, I appreciate that point, but that doesn't necessarily mean that the city couldn't choose to guarantee that right.
I don't, Mr. Norris, I don't know of any authority for you to pay for private legal counsel in a criminal prosecution under a city ordinance. I just don't know where there's the authority to do that.
Mr. Brown, what's the definition of indigent legally?
In the criminal case,
I mean, in this
I would
case.
defer to Mr. Chapman if I may.
Can you come up to the mic just so people at home can hear you?
Hi, Dave Chapman, Commonwealth Attorney here in Charlottesville. I'm here to answer questions that are technical in nature. There's a formula that's used here and everywhere else in the state to determine on the basis of income, dependence, and many factors whether someone is indigent or not.
That determines whether they can have the capability of hiring.
That's right.
Is it comparable to something that you can, we're just wondering who this is going to apply to, that we might recognize
It applies
in terms
to
of
it.
public
We had
housing
a case, for example, just today in circuit court, in which an individual whose annual income came to about $14,000, he had several dependents, he qualified for court-appointed counsel. It's a pretty generous standard, erring in favor of appointing counsel where someone has limited means.
Okay.
Actually, Mr. Chapman, while you're here, if the city were to enact this ordinance creating the local, our own local approach to marijuana, whose decision is it whether or not to prosecute under the state ordinance or the local ordinance?
It can depend. A policy can be chosen locally to do it one way or another.
Chosen by the city council or chosen by your office? Or?
It could be determined by my office. It could be determined by the police department in their charging decisions as to which route to go. For example, with an ordinary moving traffic violation, they currently elect to use the local ordinances because of the revenue ramifications for the city. So the same kind of choice could be made in the local police department. And we would not view, that is, in my office as Commonwealth Attorney, we would not view that as a particularly important issue, choosing the one way or another, provided certain things are enabled under a local ordinance or known with certainty are not possible. And you all know what you might be recommending in this. And let me give you a couple of examples about that. Mr. Fogel made reference to, and has apparently included in a version that I have not seen, the ability of the accused to elect which provision they would be prosecuted under. That's unique. It doesn't mean that it is impossible to do that, but a person who would do that in this kind of instance needs to be well informed about how to make that decision. And it's not so easy just to say, well, I want door number 1 or I don't want door number 2. For example, if you were considering choosing being prosecuted under state law, you would be subjecting yourself to the theoretical possibility of a jail sentence that could have a ramification later if you're ever charged with another criminal offense in the future. You need to know that ramification. You could also, by making that choice, have an opportunity to have access to a restricted operator's license upon conviction, and that might be very important to you. And you would, by making that choice, for sure have the opportunity to qualify for court-appointed counsel. You would, however, subject yourself to the procedural provisions that allow, on the one hand, the minimization of court costs by foregoing the lab fee if you, in effect, admit that the officer's field test regarding the proof of what substance it is admissible in comparison to having the substance sent off to the lab for testing, which requires, if a person is convicted, the payment of a lab fee. You'd need to know those things to make that choice intelligently. You would, on the other hand, want to know, perhaps as the experience of the young woman from earlier described about her experience in the immigration system. That's real. Let me tell you, that is real. That can happen to people. That's a collateral consequence that you might not face under the local ordinance, but you would, we suggest for sure, lose under the local ordinance your ability to have a restricted operator's license if convicted. If you're convicted under a local ordinance of possession of marijuana, the Division of Motor Vehicles is going to take your license for 6 months, and you do not have access to a restricted privilege to drive. Now, in the version of the proposed ordinance I saw, there was an effort to include the ability by a statute-like provision to enable the judge to take it under advisement. If you go through probation, complete it successfully, it would be dismissed at the end of the year. That provision, 18.2-251, is the means by which you can have a restricted license. But the language of that code provision, 18.2-251, is explicit. It pertains only to convictions under this article of the state code. So with the local ordinance, in light of statutory authority, people convicted under the local ordinance would be materially disadvantaged. Now, the reason I say all those things is that to make the decision about which way to go, you need an attorney. And you can't have one until you've already made the determination to go under the state code. And we see it in court all the time. Even people who have a pretty good idea, when they come forward for a first offense marijuana case, as night follows day, if they're eligible, they're going to get the 18.2-251 program. They're going to get that if that's what they want. People hesitate, and they want advice of counsel even in making that decision. Before they go anywhere, they want many times to have counsel to enable them to weigh the pros and cons for them. And it's very important for people to have expert advice at that critical juncture. So it sounds good, but it is not true that the solution is to simply let people elect which code system they would prefer to be prosecuted under. Now, there could be some avenues by which one would solve many problems, perhaps by obtaining an Attorney General's opinion as to would the language of 18.2-251 be permissibly accessed under a local ordinance. I don't know what the Attorney General would say. My own opinion based on the language is he would say, no, it can't be. One could ask the Attorney General for an opinion about would DMV, in fact, take somebody's license if they were prosecuted and convicted under the local ordinance. There might be a different opinion that one might have about the motor vehicle code and the ramifications of a conviction like this. We cannot answer those questions with complete certainty. If one purports to be able, by enacting the versions of the ordinances that are in front of you, to answer those with complete certainty, I hope you're wrong. I hope you're right, because if not, you're going to be disadvantaging people who come before the court here. There really is a need to have certainty on several points to know what you are getting into and what people would actually go through in court.
Other questions?
I had a question. Several constituents have asked me if we could do, as a way of bypassing all of this, is do what New York City just decided to do within the last week, which is essentially if they catch somebody with small amounts of marijuana, they're not going to book them. They're not going to take them back. They're going to essentially issue them a ticket on the spot that they then need to pay. Is there any provision in state code or that would allow Charlottesville to do something similar?
Substantial discretion to make policy decisions of a wide variety, including that, exist under current law. One question one must address in reaching a decision like that is the extent to which the law becomes different in Charlottesville than it is in Tidewater, than it is in Southwest, than it is in Northern Virginia, that it is just outside the limits of Charlottesville and Albemarle County. This is it's a system of law, and typically law enforcement priorities have great latitude, but by in effect directing that the law not be enforced in a certain area, you need to understand what the ramifications would be. And what are they? Well, it's a policy judgment. I can tell you, because all of the certificates of analysis for testing of all kinds of drugs that gets done at the state laboratory come before our office. They all get returned to our office. So I see them all, and I know that it is, frankly, a fraction of the cases that actually get prosecuted in courts. The officers are all the time coming across paraphernalia and substance on people, and their appropriate rules require them, when they find it, to take it into their possession and account for it, and they do so by placing it in evidence and having it sent to the lab for testing. But it doesn't mean it gets prosecuted all the time. It is bad policy to put officers or anyone else out on the street taking substances that are illegal in the Commonwealth from people and disposing of them informally. It's very important as a public policy to have consistency and uniformity in accounting for any and everything that's taken from a citizen out in the field.
And how does that relate to what New York is doing in terms of that conflict?
I don't know what accounting system they might have. They may well have exactly as we do here. People need to take something into their possession, submit it into evidence, and have it tested. They may proceed informally. And all I'm suggesting is proceeding informally is bad policy.
And I wasn't really addressing that piece of it. I agree that would need to be addressed.
Yeah.
But I was talking more about in terms of disposing of the case of, how do you proceed when you've encountered an individual who has a small portion of this substance? Is it really a good use of our resources to take them back to the police station or to get them booked, to have them then go through this entire process here? Or could we do essentially what New York is doing, which is to write them a ticket on the spot?
Frankly, we do that more
Right.
often than not.
And so I guess the question is...
Yeah, we write people a summons.
Right. Yeah. And so the question is what's the downside to making that our official policy?
Well, the policy would have to anticipate cases in which there are multiple charges. The less serious might be marijuana, more serious might be other charges.
Absolutely.
And then there are things having to do with the likelihood that a person would actually follow through and appear in court in a summons process. They haven't been before a magistrate. They've been released on a summons.
So it's doable, you just want to make...
It's certainly an option.
Okay.
Yeah, it's a policy option that can be available.
All right, thank you.
Yeah.
Why don't you stay here if there are other questions?
If I could, Mr. Mayor, if I could just add one thing to my earlier response to Mr. Norris. We do, or we can make monetary contributions to the Public Defender's Office. That law changed a number of years ago. I believe it was a bill by Delegate Van Yeries that allowed us to do that. I don't, however, know of any authority that would allow us to pay directly cost of anyone charged with a violation of a criminal city ordinance.
So if the public defender were representing an individual, they could bill the city for that?
I don't think they bill the city. I think this is part of, as part of your annual budget.
Okay.
You can make an appropriation. Right. And I don't know the constraints that office has on representing defendants, whether they represent anyone when there's not a possibility of jail time or not. But it's done, I think, typically as a lump sum appropriation.
And if I could get clarity on two things that bother me greatly about what I read here, and I don't claim, there's lots of shalls and mays and things, so I'm not entirely sure what automatically happens, but taking driver's license away and automatic treatment, drug treatment if you have simple possession. That involves not only probation for marijuana, but also for alcohol if you're caught with marijuana, which, I mean, it seems like the punishment far outweighs the crime. So under a local ordinance versus the state law, how do those two factors come in? I mean, when will a person who's caught with a very small amount of marijuana have their license taken away and have to go to this drug court or treatment?
It will happen when they're found guilty or when they are approved by the court to enter into the statutory program.
Does it always happen that something, or do they sometimes walk away with, I mean, under our local ordinance, if you're found to possess a joint or whatever it is there ever a point where you'll just pay the fine and you will
people do
go?
that all the time. People many times accept a 30-day suspended sentence, no fine, we don't take any of their money. They accept that in lieu of going down the road of having probation because for whatever reason, that's a preferable alternative. It is very demanding probation. There's no question about that. There's no question about that. Yeah. But people routinely make that decision that perhaps for them they already don't have a license or it's not important enough to them for one reason or another. They select the option of just being found guilty. And for them, the local ordinance might work exceptionally well. It would involve probably some actual fine, but not necessarily. The judge could always suspend it.
So on how does the record vary between those two, local ordinance versus a first-time offense under state law?
The record ramifications, and I'm not sure I'm completely able to answer that question. And the reason why, it will depend in part on whether or not they're processed as a part of the arrest and whether a report is made to the Virginia State Police. But as a result of the conviction or the entry into the program, whether it's a local ordinance or the state statute, the Division of Motor Vehicles is going to be notified.
They have to be. If they're not in a car, do they have to be notified?
Absolutely. Yes, ma'am.
Why?
Because that's the law of Virginia.
Really? So
it is just the law of
like
Virginia.
A punishment no matter what whether or not a car is involved, you're going to have...
It is a consequence of possessing that substance in the Commonwealth of Virginia in this day and time.
And we have to do that? Or under a local ordinance, do we... we don't have a choice of that not being part of the consequence? If it's a Class 4
I don't think City
misdemeanor?
Council has any choice.
Well, how about, but a Class 4 misdemeanor, if we declare it that also involves DMV?
The court is required to notify DMV, and that's completely out of your control.
Okay, even if it's a Class 4?
Yes. Yeah.
And-
They report all
okay.
offenses that have license ramifications to the Division of Motor Vehicles, and they don't have any choice about it.
So you're saying it has a license ramification because it's a drug, not because it's a particular kind of charge?
Whether it's an ordinance-based prosecution or a state law-based prosecution, DMV would still be notified.
Because it's a drug, not because it's a certain class of misdemeanor?
That's correct. It's because of the substance. Yeah.
Ms. Calvin, do you have any questions?
No. I also have a question about quantity. We're talking about a Class 4 misdemeanor for simple possession. Is there a quantity associated with that that is unavoidable?
There's a point at which the quantity, a half ounce or greater, creates an inference of possession with intent to distribute. So there is a point at which quantity enters into it.
And that's pretty small, isn't it?
A half an ounce. It's not a large package.
14 grams.
It's not a large package, but it can be very expensive.
And so that's, after a half of an ounce, our local ordinance applies or doesn't apply if it's 3/4 of an ounce?
That would be a charging decision at the front end of the process.
Okay. Well, and another one of my concerns is, how much discretion is built into this at the arrest point, because that's where we see disproportionality in terms of all of these, in the court, in the judicial system. Or we may. That may be one causative place. So I'm concerned about, well, this might happen or that might happen, and who's deciding what happens to whom. And is that something that is controllable, that we would say, this is what's going to happen if you are
Well, it's
found
controllable through the policies and procedures that are implemented by a police department. That's one means by which it's controllable. It's controllable by the approach that's taken in court. And as I said, as night follows day, if people want the program, they get the program. If people want to go and receive the conviction, that's what the court will do.
So I'm not entirely sure what the difference is, but what advantage there is to, that we're hearing about with this local ordinance, if it sounds like it's like the state law.
It is a practical matter. There really is no advantage, and in fact, it appears there's a distinct disadvantage for many people because it will cut off their access to a restricted privilege to drive if they're convicted under the ordinance that you have in front of you.
With the possible exception of the young woman from Chile, because a lower charge would have meant that she wouldn't have been.
That would be an example of
Sent to
a
ICE.
context in which there definitely
There'd
is
be
a
an advantage.
preferable impact. It would still potentially
That's
be
the
at the
only-
expense of
yeah.
a privilege to drive,
Sure.
but when you weigh that against the ability to come and go from the country, that's an easy decision to
That's-
make. That's one
So that's one
context.
case in which it would be, but the
Yes.
others not so much.
Yes.
So
Yeah.
can we pass an ordinance that, this will be, that we see in front of us, but that does not mention a second arrest for, that then does not state a second arrest will be a Class 1 misdemeanor? If we just leave that out,
So
what?
all
I don't know of an impediment from leaving that out. You can do that.
Well, and then a second arrest would be what?
Well,
Be
it
a
might be
Class 4?
charged
Would
under
it be a
state
Class
law.
4?
Yeah, I mean, there'll be a record of the conviction, and someone who is perceived to have a problem could be on a second encounter charged under state law. I mean, there are all kinds of ways to have solutions. Nobody's all that interested in it, frankly.
In what?
this is not a great priority for law enforcement purposes, making possession cases. It really, I don't know how to stress that more significantly. It is.
Yet the consequences of losing your license and, having, whether, you're the charge that you're convicted with and potentially going through this, as you noted, a really rigorous program that you have to pay for, is that serious?
And there's some reasons why that is. One is we're in the state we're in. And different areas of the state are far more conservative than our area. There's also a basis in the law that's related to the frequency with which people might be consuming substances of this sort and be behind the wheel, just as they might with alcohol. And that's part of the law, to try and prevent or deter people from doing that. I also have a different vantage point in this. My wife's a middle school teacher, has been for more than 30 years. And for people to see young people with the frequency with which we do, consuming substances, it's important not to encourage that in any respect. And I understand everybody here is seeking to do that. And from my own unique perspective, I see pre-sentence report after pre-sentence report where people who have been perhaps less successful academically or are comparatively low skilled begin the consumption of substances of abuse, and it doesn't matter if it's marijuana or alcohol or any other substance, at an early age. 12, 13, 14. They are rendered so much more readily subject to addiction in their later life and not that much later life when you have early onset of substance abuse. And this is one of the substances that is counted among that.
But keeping it illegal has not kept it away from the children. And I agree with you in that, but...
That may be completely true, and I don't know that the jury is in on that. There are many people who teach their children about what to do and what not to do with reference to the law. It really does go on in even our city.
Well, we could debate that, but it's, again, I would like to see whatever we can do to be as liberal towards in the direction of what I believe
Mayor
to
Husha,
be.
may we have a point of order here? Because I think these are for questions from Mr. Chapman.
Yeah.
We're entering into a debate.
Oh, okay,
Now,
that's fine.
the only thing
Questions.
I would add, and it has nothing to do with policy behind the law, just the very technical issues. Before you adopt an ordinance, get an answer to the questions that are less than certain right now, because they have real ramifications for the people in the community.
And those are,
Yeah.
could the language of 182251 be applied to a local ordinance? Can we work with the DMV so that they wouldn't so that you could have that?
Can
The
we have
partial
certainty
license
from the DMV
and
through the Attorney
through the Attorney
General
General's opinion.
whether they would for sure take a license based on a
Or
local
whether they could
ordinance
have that
conviction?
modified license?
Yes. Those are the two central questions from my perspective. Because the reality is, whether you're under the state law or under the local ordinance, it's not going to be doing anything really different than what we already do in court. That's the reality.
Other questions? Comments?
We're all ready to comment. Dee Dee, you were in the middle of yours.
Yeah, no, I would just like to see whatever we can do to move as close as we can to making this a very low-impact offense, since we have no option to go to legalization, and to try to prevent these these consequences for what is a very minor offense that, quite frankly, make the victim of the charge more likely to have difficulties in life, like taking driver's license. I mean, you might as well shoot people in the kneecaps if they're trying to work and pay their fines and et cetera. But, so whatever we can do, and it's not clear to me what that is.
Other comments?
I'm basically an abolitionist in that I think that there are very few things for which people are benefited by going to prison at all. I think that for most nonviolent crimes, prison is not the right answer. I think that, and so to me, this is a chance to kind of look at one particular thing to say, is there a place where we can look at keeping people out of jail? I think what I've seen is that as the ordinance before us is currently written, there wouldn't be any difference at all, because that's what we already have with first-time offenders. And my concern, actually, with the language that Mr. Fogel brought before us today, with the accused may elect to proceed instead under provisions of the other one so that they could get free legal services, to me just seems like a way to have a two-tier justice system where poor people end up with jail time and people who can afford lawyers don't. And so that, to me, is not the solution to this issue. I'm inclined to pause and ask for this Attorney General's opinion. I think that that's something that makes sense to me. As it is, as the ordinance is here now, it's not something I feel is compelling enough to mess with if it's not going to actually improve things.
I'll be willing to say something now, and I'm sure I'm going to be somewhat of the minority opinion on this, but I want to bring another perspective on this, and that is looking at the existing criminal justice system that we have and how it's been dealing with the issue of marijuana and substance abuse, because one thing I do have to thank Mr. Fogel for is that it made me really burrow deep into what we are doing so that I can see that we're following best practices in many, many ways in our regional criminal justice system. And let me kind of review a few things, if I may. And I do want to also underline that the reason why I first even entertained revisiting the sentencing issue was because I did want to make sure that people were getting drug treatment, not going to prison. I do think that marijuana is a drug, and it's something that can become addictive. We have just received word from one of our mental health professionals today that it is very much, for many individuals, addictive. So it's not something to be viewed lightly. In fact, I believe it was Netherlands, which is really beginning to reconsider whether or not they should be closing their marijuana shops as opposed to opening more of them. So I also want to point out that I wanted to make sure that the low-risk offenders were not being put in a pool of high-risk offenders, and I want to make sure that we were spending our law enforcement dollars wisely and using best practices. So in light of those concerns and in light of this ordinance discussion, I did come across a very important report by the NAACP called Over-Incarcerate and Under-Educate, and it was put out in 2010. And they had 11 principles to follow in order to address and cause a paradigm shift in your criminal justice system so that you were really investing in an alternative diversion away from prison, which seems to be the other theme that's very strong here. We're concerned about people of color, people who are indigent, getting put in prison when they really need to have substance abuse treatment and mental health care. So with that, I used it almost as a rubric, their 11 principles. And I went and took that rubric and talked to OAR, the Offender Aid and Restoration Office, and probation, as well as our criminal justice planner and our human resources director. So the first thing you're supposed to do when you're wanting to make sure you have a progressive, evidence-based program for your criminal justice system is that you study the problem. We've just already approved our payment to be a partner with the Disproportionate Minority Contact and Juvenile Justice Task Force efforts to reduce the disparities. And we're also currently looking at data with regards to the adult system to do a similar evaluation. The next step is to look at creating reinvestment commissions. We have a justice reinvestment project in our Charlottesville-Albemarle regional system. That is looking precisely into identifying legislative and policy avenues to downsize prison populations, and shift savings from prison to other priorities. We have a One Less initiative executed by the Evidence-Based Decision-Making Project Policy Team, of which Mr. Chapman is a member, as well as our own Police Chief Longo. And they use evidence-based decision-making. They turn interaction within the criminal justice system into an opportunity. That's a goal. And they operate collaboratively with all the agencies in both city and county. This is one of 7 seat sites in the entire U.S. We're pretty unique in how we approach this issue. Are we using our monies wisely? Are we putting low-risk people into a high-risk population? Are we diverting them from prison and giving them the care they need? Eliminating disparities in drug laws. I mean, the big issue nationwide has been crack and powder cocaine. President Obama dealt with that in August 2010. There isn't that issue of any kind of sentencing discrepancy in marijuana. And again, when I look at the evidence, people are, when they are found with simple possession, they are given the choice. They can go with a deferred judgment. At that point, they are undergoing treatment. They will then not have that on their record. In talking to our professionals, I find out that a lot of them are college students that opt to do that. And I'm reminded of the discussion we had with regards to the noise ordinance not too long ago about how having a threat of a severe fine and possible even jail time was enough to make a lot of the fraternities turn around and assist our police department to work with the neighborhoods to limit the noise. So we understand with certain populations, in this case this was a college population, they were interested in not having that on their record. So is the question then the race of the people that haven't chosen that route, or is it the race of the college kids? If we don't have enough minorities in the college population, shouldn't we be working on that as the issue, not looking at the fact that many of the people that are then recidivating in marijuana use, there's also other tendencies to other kinds of criminal behavior. It's not just marijuana. So second, third, and fourth encounters with the law, it's not only with regards to marijuana. There's a penchant for criminality. That's what I've been told. So then we increase earned time. That's an issue about allowing prisoners to earn an earlier release by participating in educational and vocational programming, as well as drug and mental health treatment. Greg Fairchild from Darden School has developed a pilot and educational vocational program about that. Mr. Robert Johnson of Region 10 also stated that marijuana fits the categories of drugs that are used, abused, and for certain individuals can be addictive. Yet again, the proponents of all the 3 different ordinances now we have before us have said that it's harmless and it will curb the black market. That has not been substantiated. The 5th point in the NAACP comprehensive approach is to support youth violence reduction programs. We have a gang awareness task force, which recently got a $35,000 grant to study gang behavior. And again, we have that we're funding the efforts of the Disproportionate Minority Contact and Juvenile Justice Task Force. The 6-point reform sentencing and drug policies. Again, that's talking about eliminating mandatory minimum sentencing. But what I have discovered is the first-time offenders under our current marijuana ordinance do not get incarcerated. They have a choice. They have a choice. There's an elective treatment and diversion program that removes the charge. By creating a local ordinance that conflicts with our state ordinance, we might be guilty of the law of unintended consequences. So again, I'm very, very, very nervous about tampering with something that might have, in fact, remove some legal rights to individuals. Use diversion for drug-involved individuals. We're using diversion for marijuana via the OAR's deferred judgment program, and for felonies, there's drug court. Shortening prison terms. This is directly related to some of the work of the Justice Reinvestment Project. Increase parole release rates. Again, this is the One Less initiative being executed by the evidence-based decision-making project policy team. Reduce revocations of people under community supervision. That's developing alternatives to incarceration. That's, again, a topic of the Justice Reinvestment Project. Supporting reentry. There are reentry efforts at the jail, the inmate work program, and a regional reentry council. Our council has expanded the reentry apprentice program through the Parks and Rec. And we have, as a council, submitted, as part of our legislative package, support for House Joint Resolution number 535 that would allow the restoration of voting rights to a greater number of persons disqualified due to a felony. So, in conclusion, of the 11 points that I found in that NAACP report, we are working very well and very hard to create a just system. And dealing with one small ordinance is a little bit like the tail wagging the dog, and it may very well not do what everyone wants it to do. So I cannot support the proposed new ordinance with or without teeth. I don't think it's necessary to divert first-time offenders because we're already doing that and we provide education and treatment. It could unintentionally create more harm than good because it'll be out of sync with our state law, and we do not understand, no one here understands the implications. It would signal that marijuana use is harmless instead of promote treatment, education, and opportunity. It ignores the good work being done by our regional criminal justice network. And the council's legislative package request this year already asked the Virginia General Assembly to re-examine the laws concerning marijuana possession. So I think we've already done what's prudent under the law, and as what's recommended by such groups as the National NAACP. And while Virginia's General Assembly is looking over its legislative package from all different localities in the state, we'll be able to see and listen and watch about the success and failure of other states that have legalized marijuana. And I believe we can also take some, learn some lessons from countries like the Netherlands, who are in fact revisiting their very, very liberal marijuana policies.
Other comments and questions?
So this is a sort of a bizarre conversation we're having because we're, figuring out on the local level, or some of us are trying to figure out on the local level how we make marijuana illegal locally in a way that's going to send a signal that we don't think it's as serious an issue as the state might. But frankly, if I could wave a magic wand, we legalize it locally. We can't do that, though. So in the absence of clear authority to simply legalize or decriminalize it locally, I do think that we have heard tonight about some options that we can pursue to send a signal that this is not, in fact, a high law enforcement priority, which we've heard from our Commonwealth Attorney and we've previously heard from our police chief that it is not, in fact, a high law enforcement priority. And I feel like our policy and our message should reinforce that and mirror that. And so, for instance, we heard tonight that in many, if not most cases, we already do what New York City, and I'm going to read it in case anybody hasn't heard what New York City just agreed to do last week. This is a paragraph from Mayor Bloomberg's press conference. He said, "Right now, those arrested for possessing small amounts of marijuana are often held in custody overnight. We're changing that. Effective next month, anyone presenting an ID and clearing a warrant check will be released directly with a desk appearance ticket to return to court. It's consistent with the law, it's the right thing to do, and it will allow us to target police resources where they're needed most." That seems to me a very simple, common sense thing that we can do to send a signal that this isn't a good investment of our police resources. So I would urge council tonight to take action to adopt that as official city policy. Number two, I had a question for Mr. Brown. In your proposed ordinance, you had as a first violation that there would be a fee of $250. Can you tell us where that number came from?
Up to $250. That's, the state has 4 classifications of misdemeanors, and a Class 4 misdemeanor is punishable by fine of up to $250.
Okay, I thought it was 500. Is that not correct?
That's Class 3 misdemeanor.
Okay. 'Cause your
And,
memo-
and the proposal that was made to you from the original ordinance submitted by Mr. Fogel made it a Class 4 misdemeanor.
Right. I think in your memo you had it at, well, anyhow. So can the locality essentially say, because state law allows a fine of up to X number of dollars, could the locality set that fine lower?
Well, that's what the proposal is.
No, I'm
Setting
saying,
it
could
up
we
to-
say, for instance, that we're only going to fine somebody $25 if they're caught for a first-time offense?
I wouldn't endorse any ordinance that was inconsistent with state law.
I'm sorry, you?
I would not endorse an ordinance that was inconsistent.
Well, I'm
with state
asking if
law.
it's consistent. The state law says it should be a fine up to X number, $250. If we said as a matter of policy that in Charlottesville, the fine's only going to be $25 or $5 or 50 cents or whatever it is, as a way of sending a signal that this, well, go ahead.
Are you saying that would be in the ordinance, or that would just be a policy? I mean, it's generally up to the judge to decide the amount of the fine.
We don't control.
It sounds like you're kind of creating a new class of misdemeanor.
Well, no, I'm saying that, I'm asking for your legal opinion. I mean, I read state law to say there should be a fine of up to X number of dollars, $250 for a Class 4 misdemeanor. And I'm saying in our local ordinance, $50 or $25 is in that range. It's up to $250.
Right. I guess I'm asking whether you want the ordinance to say that.
The local ordinance, yeah, that's what I'm asking.
To say a fine of no more than
Right now, it
$5.
says $250.
I think the question is,
It's no longer,
do we have the authority to tell the judge how much under $250 it is?
no. In my opinion, you don't.
Okay.
Does it have to be a misdemeanor? Do we have the authority to, I mean, I'm just wondering, if, to make a fine of $25 is no longer a misdemeanor, I take
Yeah.
it?
You're
Because-
asking, can you decriminalize it? No.
That's what that means.
Yeah, we know we
It's not, I
can't.
guess.
No, that's a good question. I mean, all right, so let me continue on my list. So I think I would like to see us adopt a local ordinance. I would like to see us enter in an agreement with the Public Defender's Office that we would essentially contract with them or provide financial support for them in exchange for representing anyone who's prosecuted under the local ordinance. Give them an option to have defense, legal defense. I'd like to see us petition for a clarification on the DMV policy. I think if we're being realistic, that the idea that, we're expecting Ken Cuccinelli as our Attorney General to give the green light to liberalizing marijuana laws, I don't see that happening. And so I think that will be a path towards inaction. But I do think if we can work on clarifying what the DMV policy would be regarding violation of a local offense versus a state offense would be good. And I do think Mr. Fogel made an excellent point in his comments today and previously about shifting the whole way we approach drug possession from a criminal matter, particularly marijuana possession from a criminal matter, to a public health matter, and taking a really hard look at resources that are available locally or not available locally for drug rehab, because we know they're lacking, particularly, and alcohol rehab for that matter. But so I think if we can do these things, adopt the New York policy about interdictions, adopt a local ordinance, funding for the public defender to allow individuals prosecuted under local ordinance to have access to legal counsel, petition for a clarification on the DMV policy, and then a real hard look at drug rehab and alcohol rehab in our community. Those things, I think, would they're all baby steps, but I think they would move us in the right direction.
All of you had a chance to speak. Let me make a few comments. This is a very passionate issue for many people, and it affects many lives of young people as well as old people. And it is a issue of not only legal aspects, but also a policy issue for which we can influence to some limited degree. It seems to me that under present situation, we are not incarcerating in Charlottesville anybody on the first offense. And I think by trying to fool around with the legislation, you will endanger the situation and improve the situation in my mind. You lose the legal services which are available now under state law. It will have a question of licensing is important. They'll lose that. It is our administrative policy at this time not to prosecute first-time marijuana offender for jail. And I think that is a good policy and it should continue. And I feel that no valid purpose is going to be served by changing the ordinance at this time. Actually, you'll lose some of the privileges you have instead of you gain. And so I'll be opposed to this.
I would like to just put before our police chief for kind of future consideration the New York policy. I think if it is something that our police support, I think it would be a good policy for us to do. I think for us to do it tonight would be premature, having not kind of taken that step. But I think that sounds like something that probably already is our policy, and we might want to codify that.
Or it's our practice.
Mm-hmm.
Yeah.
It is our practice. So are there motions to deal with this issue?
Mayor Huja, I'd like to make one more comment, and that in light of the fact that we all seem to agree that we would need more discussion and understanding of the need for greater public health and substance abuse counseling, and that we also have a very willing criminal justice network of professionals that want to meet and engage with this council to discuss future policy, especially in light of the pending expansion of the jail. And we might very well need a good discussion with our community stakeholders, with our mental health and public health officials, and our criminal justice professionals. And let's have a really engaged work session end of the spring and the summer as we kind of move towards making investments in, say, our prison system, when we would really need to be investing in treatment and educational alternatives. So I would like to propose that.
I'm not necessarily opposed to a work session, but I think that, as you mentioned in your talk, that that's already happening in the community, and rather than forcing all those folks to come to our work session, it might be better if we kind of individually go to those meetings.
Well, they suggested this as a way to have a thorough engagement.
Mm-hmm.
Are there any motions this evening?
I'd like to ask if we can direct staff to speak to the police chief and to see if this is a policy that seems, that could actually come from staff, that might be something we would consider. And I don't think that there's anything wrong with asking for an attorney general's opinion on those two issues. I think that it might serve to kind of pave long-term, way for eventual things all over the Commonwealth. So
I agree with Mr. Norris. It is a total waste of time,
Well,
given who's going to give you an opinion.
I won't push it because I do know who the attorney general is.
I would be in support of the idea of our administrative policies, talking to our police people and court people. And
I missed your last statement, I'm sorry.
To talk to the police and the Commonwealth attorney to institutionalize this policy we are already doing. Is there any other motion?
Well, I'm going to move that we approve. I may not get a support for it, but I'm going to move that we adopt the language proposed by Mr. Fogel.
Which the public has not seen.
Actually, I'm not even sure I support the one that he's proposed tonight, because I do think it's a little unwieldy. I think his original proposal was very clean and very simple, which makes marijuana simple possession of marijuana a misdemeanor, a class 4 misdemeanor. And that we, in order to address the inequities in access to legal counsel, that we agree to contract with the Public Defender's Office.
So you're moving the first version?
That's
Do you want
correct.
to read it so that we know what, I think.
Actually, I don't have Mr. Fogel's first version on me, except I have.
But that too, the public has not seen.
Right, this way it
Okay.
would be easy enough to.
Is there a second to the motion?
Well, I will second it if we can read it out loud. Because I think the public needs to.
I just want to ask a question. Everyone is confident and understanding of the consequences of passing this local ordinance.
Well, it hasn't passed yet.
No.
I'm asking the question.
I think we understand.
Maybe rhetorical, but.
So, if somebody have a copy of Mr. Fogel, do you have a copy of your original ordinance?
He's looking.
First one you sent to us.
I have it, Mr. Mayor.
Okay. Would you please read that, Mr. City Attorney?
A, it is unlawful for any person knowingly or intentionally to possess marijuana unless the substance was obtained directly from or pursuant to a valid prescription or order of a practitioner while acting in the course of his professional practice or except as otherwise authorized by the Drug Control Act, Virginia Code Section 54.1-3400 at sec. Upon the prosecution of a person for violation of this section, ownership or occupancy of the premises or vehicle upon or in which marijuana was found shall not create a presumption that such person either knowingly or intentionally possessed such marijuana. Any person who violates this section shall be guilty of a Class 4 misdemeanor. B, the provisions of this section shall not apply to members of state, federal, county, city, or town, law enforcement agencies, jail officers, or correctional officers as defined in Virginia Code Section 53.1-1, certified as handlers of dogs trained in the detection of controlled substances when possession of marijuana is necessary for the performance of their duties. C, the provisions of Virginia Code Section 18.2-251 relating to probation and dismissal for first offenders under certain conditions shall be applicable to a first offense under this section.
Okay. Is it the motion you're making, Mr. Norris?
That is the motion I'm making. I would add a provision about providing access to public defender through a contract the city enters into with the Public Defender's Office.
Is it the motion you're seconding?
I'll second.
Any discussion on the motion? I have already mentioned to you that I plan to vote against motion of this nature because I think it will do more harm than good. Any other
Shall we
points?
vote?
No, it is the first reading.
Oh, first reading? Well, in that case, I'll also say that I would not support it.
And I would not support it for reasons I've already stated.
Okay, thank you.
I do think there is agreement, though. We got at least the majority of councilors agreed
Absolutely.
to pursue
Yes.
The policy.
institutionalizing the
Yes,
policy.
I think there is agreement on that. Next
and
item.
I fully agree with Ms. Galvin's request or suggestion of a work session to look at resources for treatment, look for resources for rehabilitation. I think that has to be part of the puzzle, so
Yes,
thank you.
I agree.
And the reason that just to kind of clarify it, the reason that I would oppose that policy is because I think it does do more harm than good. I think that we would either create a two-tier system or we would have people who are being punished unjustly by being stuck with things like no driver's license, who would not have those penalties if they were
Okay.
prosecuted under current law.
Any other comment on this issue?
Well, seeing where the votes are, I do, even though I don't know how much fruit it will bear, I wonder if it is, worth trying to get some clarification on whether these provisions could apply to a local ordinance, whether the DMV provision could apply to a local ordinance.
Is there any reason that we can't ask for that opinion from the Attorney General?
You could certainly request an opinion from the Attorney General. And bear in mind, one of the answers may be to
Not
call
gonna give
into
you an
question
answer.
your authority to do this at all.
Okay. Well, that'll give us part of an answer.
That's the risk you run.
Well, I'm not sensing there's support for it anyway, but if the Attorney General were to come back and say, you could do it, then maybe that would get us a third vote.
It would give us
so.
the knowledge we
You have a
need.
dreamland, I would say you live in. Okay. I think.
So just as a point of order, if that was a first of two readings, does that mean we have to go through all this again, or are you withdrawing your motion?
Well, there's clearly not a third vote for
No.
it, so
But I think you only need 2 for a first reading.
I know, but her question is it worth even proceeding knowing that we're not going to get a third vote on it? And so I've made my motion, it's been seconded for the record, but if there's no chance of getting a third vote on it, I'd just as soon pull it so that we can explore
bring
some
it
of
back
these
another time.
other
I
avenues.
think that'll be better.
Thank you.
And then, and again, if the Attorney General comes back and says that we can apply those provisions locally, then maybe we'll get a third vote.
Okay, thank you. Next item on the agenda is stormwater utility. Staff report.
Ms. Rittervall will be presenting, and I think she has a PowerPoint presentation. So.
Okay.
Having a break.
Oh.
Good evening. Thank you, folks, for being here, and it's a pleasure to share with you an update on the stormwater utility proposal. I was asked by Mr. Jones to give a PowerPoint of much of the material that's been shared in the past so that it can inform the discussions this evening. The proposal that we're bringing before the council would provide adequate, sustainable, and dedicated funding for a water resources protection program that we've summarized and presented both in this room and through other means, such as the open house and having that information available on websites. I just really briefly want to show you what we're going to go through today, a bit of the background to our efforts, an overview of the stormwater utility ordinance itself, an overview of a resolution establishing a Water Resources Protection Program Advisory Committee, and then there will be opportunities for questions from council. So as you see, one of the top things in the background is the drivers for the exercise we've been involved with. So those drivers are most simply described as failing infrastructure, aged infrastructure, situations of flooding and drainage problems that either require capital improvement projects or can be addressed through comprehensive, ongoing, effective maintenance of the existing system. There's also an entire realm of regulatory requirements, largely driven for water quality goals, whether those be for local streams or whether those be for Chesapeake Bay, established limits referred to as total maximum daily loads. And I would just offer to the audience that the regulatory requirements associated with the Chesapeake Bay are anticipated to be very expensive for the community, not just for Charlottesville, but for all other communities that operate under a Phase 1 or Phase 2 municipal separate storm sewer permit. There's also the reality of facilities that are in the ground either on public or private land that do perform a stormwater management function, and whether that's the inspections, the maintenance, the construction of these in order to meet regulatory requirements. Suffice it to say that we don't currently have a comprehensive long-term plan to deal with these challenges. And in part, that's because there has not historically been consistent or appropriate funding to plan, design, or implement the type of capital projects to address these drivers. Just a quick tour of sort of the timeline that we've been working on. I actually came to council in 2003, shortly after I joined city staff, and just provided council with a presentation on the concept of a utility. We had the opportunity in the first couple years of 2000 to get some funding support, cost match from the Corps of Engineers that was encouraging localities to consider long-term dedicated funding approaches. The issue of water protection and local water quality was implemented in the form of a water protection ordinance, which is Chapter 10 of our city code. That had originally been erosion and sediment control. It was expanded to include stormwater management regulations, stream buffer establishment, the authority to go after incidents of illicit discharge, so non-stormwater or toxins or pollutants or illegal dumping in our system. 2006, we met with the city council at that time and just had a work session on the general topic of stormwater, water quality challenges, efforts, and goals. You can then see that in 2007, there were a number of commitments made by city council in the form of a 2025 vision, in the form of the published comp plan that had a variety of water quality and stormwater goals and objectives. And then there was a September presentation to council on the program status, on the regulatory requirements, and on the ongoing challenges. There were a variety of funding options that were presented to council at that time. And for the record, I would like to point out that the consultant support we had at that time is not the same consultant that we're working in our current efforts. 2008, in early part of the year, we had a budget work session with City Council. There was direction to evaluate the funding of a program through a user fee, and it was to be based on involvement of city staff, technical consultants, and an advisory committee. So at that time, we convened a 15-member advisory committee that represented a very broad stakeholder of the community, both nonprofits, residents, businesses, institutions, interested parties, and I'll share with you the similar configuration of our most recent advisory committee. The recommendations from that effort were presented to council in November of 2008. The report that summarizes the process and the recommendations was posted to the website. And again, I'll go into a little bit of the detail of that process. 2009, council indicated that the proposed water resources protection program and the stormwater utility was a long-term strategy. But due to a variety of influencing factors, the decision was made to delay the implementation of that program, of that utility. And with that delay, there was no further work on development of credit systems, no further work on development of master account files. We essentially went back to working on stormwater with the existing funding. At that time, council did agree and subsequently did designate funds to do some specific work related to infrastructure rehabilitation based on the compelling case for our failing infrastructure and the value to the community of that system. So fast forward to 2012. In July of 2012, staff gave another stormwater program update to council. We provided a summary or the status that there continued to be limited funding available that was dedicated for stormwater program components. We had a much clearer picture of the increased regulatory requirements, in part because the permits and the permit conditions that are applicable to communities like Charlottesville are now in draft mode and are anticipated to be adopted for full implementation in July of 2014. So those were items that we were speculating back in 2008, more than we were in 2012. In July, council approved the recommendation to update the 2008 program and to reconvene an advisory committee, essentially to vet the appropriateness, the program level of services, the type of rate that would support that type of program. And there were various outreach efforts associated with this. I'll go through these as well. So that brings us to 2013. We were in front of council on January 7th with a comprehensive report that contained the findings, the process and the consensus and the conclusions of the advisory committee. We came back on January 22nd. It was a noticed public hearing, and it was also scheduled to be the first reading of the ordinance. Based on comments received at that time, and I think we had 28, 30 comments in person here. There were numerous emails and correspondence with council. The decision was made to reschedule that first reading, so that was then held on February 4th. And that brings us to today, where the decision was made to proceed to a second reading of that ordinance with some adjustments based on the discussions. So to give you a quick overview of what happened with the 2012 project, the task staff and the consultants and the advisory committee were given was to review and evaluate the option of funding a water resources protection program through a stormwater utility fee and have that effort driven by a window of time that would inform the FY14 budget. So that process included a very comprehensive review and updating of the 2008 recommendations. We did re-engage stakeholders in the funding discussion. A lot of this effort is done most effectively when the community steps back and looks at what are the current level of programs and services, what do they cost? What are the required or desired programs and services, and what do they cost? And once that delta can be established, we can have informed conversations about funding that. The rate model, which is how we land at a fee rate, a per billing unit per month type approach, was based on the updated program plan. It was based on updated available GIS data, and it was based on public feedback, including significant conversations had with our advisory committee. And we were then tasked to submit the updated proposal, which happened on January 2nd, and then a draft ordinance, which was presented on January 22nd, 7th and 22nd. I just want to point out, these are the members of our most recent advisory committee. You'll see that they do actually represent a similar makeup that I described before: neighborhoods, businesses, institutions, public housing, faith-based community, environmental groups, and other stakeholders. These folks spend a lot of their personal time and effort to think through these difficult issues with the team, so I commend them again for that. The priorities that this group landed on are consistent with what you saw as the drivers. It had to do with enhancing operation and maintenance of our existing system. The technical term for that is rehabilitation, whether that be through lining pipe, whether that be through replacing pipe, whether that be through clearing out sections. It is really to maximize the asset that this community has already invested in. Meet increasing regulatory requirements. Many of the folks, especially in the business community, have been tracking the increased regulatory requirements because it has implications on all development and redevelopment, and it has implications on the pollution loading that we as a community are obligated to achieve over a period of time. And then it also involved an acceptance that developing a citywide master plan would be a very appropriate way to integrate our multiple goals of water quality protection with the need to fix our system. Understanding that if we have a dedicated but discrete pot of money, we need to find out where to do the best project in the best location to accomplish the most goals at any time. We're never going to have the endless bucket of funds to do what could be done. And then investment in long-term drainage improvements based on various stormwater drainage models that we have. There are places in the city identified as current and future flooding challenges. So basically the challenge is, once you've identified your current program costs and your future program costs, how do you fund that? So we've had on various occasions conversations about how to do that. You can either generate new revenue, and one way of doing that is through a user fee, which is based on contribution of the parcels throughout the city to stormwater runoff. Another approach is to generate revenue through the real estate property taxes based on the assessed value of properties. And then a third option is to reappropriate current funding, to essentially work through the general fund process to identify the dollars needed to deliver the program of services that this community, through its advisory committee, has indicated is desired or needed. I'd propose that there's actually another funding approach that was discussed or that's been pursued, which is a hybrid approach where both general fund and user fee revenue would be used to support the full program, and that's the proposal that's currently being contemplated. I apologize if you can't see all this, but the purpose of the slide was to share with the audience and to information that we shared with our advisory committee, and which was available at many of our information sessions. There are a majority of the localities in Virginia that have a dedicated funding source for stormwater that have opted to use a utility approach. Our consultant was not involved in the development of the utilities for many of these localities. Many of them initiated that process and adopted their utilities in the early 90s. They're what are called phase 1 communities. They're significantly larger, and the requirements apply to them earlier than they did to Charlottesville. And so these folks at the top of the list essentially join over 1,000 other localities across the nation that use a utility system to fund their stormwater program. So when we went through the process of evaluating a stormwater utility fee, there are a couple of basic...
Could you go back, please?
Sure.
Could you make comments about the bottom three also?
So at the bottom, there are Fairfax, Arlington, and Alexandria are 3 localities who chose to increase property taxes or dedicate a cents on the real estate tax to stormwater. And at least one of the communities, I believe, has had to go back and add a penny. I think it's Fairfax that started off with 1 cent on the tax rate, had to increase it to 2 cents. And we've heard, I haven't found any further information, that whether it's communities in Virginia that use the tax rate or others, some are also looking at adding a utility to their funding portfolio. So again, a lot of it depends on which funding approach made sense in which locality and for which reasons. I would take us to this slide, which essentially would like to convey that the approach of a utility is a fee for service. Localities can't do it in Virginia, but for the state enabling legislation, and that legislation is fairly prescriptive on some of the things that must or must not, or may not be covered in the program. It is a program of services, and as I described, how to fund the delta between your existing program and your desired program essentially defines how much money is needed, and it is entirely unique to every community. If you're a new community and you're growing out into rural areas, you're expanding your infrastructure, that's a different program cost than if you're an older built-out community with an existing network that needs repair and rehabilitation. It is a dedicated source of funding, so the dollars that are collected through the fee are earmarked for stormwater-only work. It can't be then used for any other discretionary purposes. That legislation is very prescriptive that those dollars are reserved to meet stormwater program requirements and commitments. The properties contribute to the fee or to the revenue regardless of tax status. One of the points that is associated with this is that your revenue source doesn't change as a result of assessments going up or down. In many ways, that makes that revenue source very predictable for the long term. So the rate that we have currently proposed in the ordinance it generates sufficient revenue for the program needs identified. And because that's based on facts that don't change very much from year to year, meaning the impervious cover in a community, it's possible to predict the long-term resources that are available, which provides for strategic, sustainable planning efforts, and then ultimately the capital investment in the recommended projects. I do want to share again the findings that were arrived at with our advisory committee. The committee found that there is a compelling case for funding of enhanced stormwater services. The committee supports the level of services that were in the report that have been posted. that were presented in January but have been posted to the website since November. The committee concluded that the funding through a stormwater utility is fair and equitable, that a credit policy should be adopted as part of that program, and we've gotten a lot of comments on the credit policy. I'll speak to that in just a second. The committee supports establishing the fee to fund new program costs and to maximize the use of bonds, which is the approach the current ordinance contemplates. Establishment of a citizen-based oversight committee, hence the resolution that's part of the agenda item today, and then certainly an encouragement of regional collaboration. Much of that builds on what's currently happening, but that's not to say that thinking about stormwater and water quality through a watershed lens versus a jurisdictional lens isn't valuable for the whole region. So briefly, so as I mentioned, we had a 15-member advisory committee in 2008. We had a 13-member advisory committee in 2012. They represented a similar makeup of stakeholders. Some were repeat members from one round to the next. We had a dedicated web page where all the meeting notes from 2008 are still posted, as well as the final report. And there's access to a tool that was developed in the fall so that folks who weren't able to attend meetings would have the opportunity to access all the material available from those meetings, but also look at what the information about a specific parcel might be. We set up a dedicated email and phone number to field inquiries or comments and questions, and I can report that since those were set up, we've been fielding a very ongoing routine number of comments and questions, often spiking after the 3 previous presentations we've made this year. In November itself, we had an informational meeting for environmental groups and other groups who had expressed interest in the city tackling the subject of stormwater management and its funding. We had 2 focus group meetings. One was for representatives of the potential top fee payers, and another was for representatives of tax-exempt properties. I will admit that I can't guarantee that that was 100% accurate, the mailing that was sent out, but we sent over 200 letters to invite folks to these meetings. And again, the understanding that the meeting took place on the Tuesday after Thanksgiving and with 2 weeks' notice, the goal has always been to keep that information on the website for follow-up review and opportunity to ask questions. We had 2 drop-in informational open house sessions in City Space in November, and then we've had a variety of media coverage, some of which was in response to media inquiries, some of which has been organized and volunteered by some groups who find this subject very important and want to help get some information out there. Moving along, the ordinance that is before council is largely the same as what we reviewed at the February 4th meeting. It establishes the utility. One difference here is it sets a billing unit at 500 square feet. Previously, it had been 1,000. It sets the rate at $1.20 per 500 square feet per month. It waives fees consistent with the Virginia Code. It requires the development of a system of credits for council's approval. It establishes the billing and the collection procedures. It establishes an appeals process, and it incorporates many of the suggestions that were made off the first version, and it sets an effective date of January 1, 2014. There's another item with the agenda packet today, which is a resolution establishing an advisory committee. That would be a 7-member committee, and you can see that the makeup of that committee is anticipated to be similar to the makeup of the stakeholder committees. The duties would be to engage in matters pertaining to the program, to conduct periodic assessments of the program, which would include looking at the accomplishment of objectives and how some of those types of things would or should influence rate adjustments, monitor the formulation and implementation of the Water Resources Protection Program, basically hold the program true to the commitment that was made. If it's going to fix infrastructure, report back on how much of that infrastructure was rehabilitated. If it's going to do master planning, what are the outcomes of that master planning process? meet with the program administrator to make recommendations, and those recommendations on policy could range from anything from credit programs, incentive programs, program priorities, and then report back to council. So tonight we have the opportunity to field additional questions. There's the opportunity to conduct the second reading of the proposed ordinance, to adopt a resolution establishing the committee. We are obligated to bring back policies for the credits, the incentives, and the assistance programs, and that would happen prior to the effective date of the ordinance. And the first billing associated with this utility would occur in the spring of 2014 for a first 6-month program period.
You heard the opportunity to have a staff review of the process as well as the plan for your comments and questions you'd like to. Mr. Norris.
I'd like to go back to the service district discussion. And do you know whether or not in those 3 localities that the service districts were specific categories or specific sub-areas of the jurisdiction, or did they break up the jurisdiction into equal pieces based on a drainage plan?
I don't know the answer. I know there are communities where a large part of the jurisdiction is agricultural, that the district is established around the area that has the highest density of development.
So it's a way to basically provide infrastructure for specific areas, but not necessarily the entire jurisdiction.
Correct, but again, some of those may have been developed prior to the Chesapeake Bay pollutant requirements, and I think that may inform localities to take different approaches when the commitments or the pollution reductions are not limited to certain areas.
Okay.
Do you recall off the top of your head how much the city was budgeting when you arrived on an annual basis for stormwater improvements? Roughly?
I don't know what the exact capital CIP funding would have been, but there was a limited 30-some thousand for basic program, compliance program costs.
And I think the capital budget, if I remember, I don't know, Mr. Jones, if you remember, or I want to say it was a couple $100,000 a year.
Yeah, I think that's about right.
And I think it changed from fiscal year to fiscal year, depending on certain drainage projects that the city was looking to accomplish.
Right, but on an average basis, it was a couple hundred, if I remember correctly, it was about a couple $100,000 a year. And
Yeah, I think-
what is in our, can you tell the public what's in our current budget for, in the capital budget and the gas budget for stormwater improvements
Currently.
currently?
In FY13, there is $600,000 budgeted for the rehabilitation work. There's $166,000 for the small drainage program that NDS manages. And then there is an 100 and some thousand in the gas fund that in previous years has been used to support some of these regulatory and planning efforts.
So it's about 900,000 total, roughly.
Yep.
So we've gone from a couple 100,000 5-6 years ago on average to about 900,000 now. And also, can you tell us, when you arrived, how active was the city in terms of putting into place best management practices for stormwater retention, biofilters, et cetera?
On our own projects?
Yes.
I think that the first pilot project, if you want to call it that, implemented rainwater, bioretention was a rain garden in Greenleaf Park.
Right, but
and
that was since you arrived.
Right.
I'm saying before you arrived, or...
There were, at that time, not really big
No.
construction projects that provide an opportunity to do that. And the approach of retrofitting public lands was still sort of in its infancy,
Right.
so that Rain Garden and Greenleaf would have been the first attempt at showing what that could do and what that could look like.
And there have been a number of others since then.
Correct.
That you deservedly have gotten a lot of credit for.
Well, and in many cases, it should be pointed out that we've chased grant money and
Mhm.
really tried to aggressively look at opportunities to bring those types of projects without using local funds.
Right. What about monitoring of our city waterways for pollutants? When you arrived or before you arrived, how much money was the city investing in monitoring the city's waterways? How much, for instance, how much money were we providing Streamwatch or?
Streamwatch didn't exist at that
Right.
time.
So was there any concerted effort at that time to monitor our waterways?
I believe that we and most communities depended on the limited monitoring that the state provided.
Right. And now we're funding Streamwatch, where there's an active program in place to monitor the waterways. The point I'm trying to get at here is there was a statement made earlier, and I have all the respect in the world for Ms. Savage, but the statement that she made earlier, and I wrote it down word for word, that the city council has delayed action. And the reality is that we have taken substantial action in the last 5 years. We've increased funding from a couple $100,000 a year to $900,000 a year. We're actively monitoring our waterways. We are investing in best management practices. Have we solved the problem? Clearly not. Within our existing resources, clearly we haven't solved the problem. But I have to push back on this notion that we haven't taken action, or we've delayed action. We may have delayed action on this proposal, and that's an accurate statement, and maybe that's what you're referring to. But we have taken this issue seriously. So, and I want to get at the other issue, which is this idea that there's a certain dollar level. Neither the state nor the federal government require localities to invest a certain amount of money on a per capita basis, or a certain amount of money, period, in stormwater improvements. Is that correct?
That is correct. The state, through the MS4 permit, is establishing pollution reduction loads, and it doesn't dictate to the permittees how those are to be achieved.
Right.
There is the implication that non-compliance comes with a penalty.
Sure.
And it's difficult to project what that would be if 10% of the requirement was met or 100%.
Right. The chart you put up showed that some localities are doing as small as $17 per capita, and some are doing as high as $70 per capita. I forget, maybe there were some outliers on either end, but it's a pretty broad range. And obviously, as you say, that's partly reflects the circumstances of each locality being different.
Right,
And
what the program
what the
costs, or
program
what's the
costs.
level of service that community lands at.
The proposal here is for a rather ambitious level of service. It's, I think I calculate to about $60 to start per capita, which compared to other localities is fairly ambitious. It's not the highest in the state, but it's fairly ambitious. But basically what I'm trying to get at is, you referred several times in your presentation, there's a desired level of service that this formula is based on. And I just want to sort of put it out there for the public's understanding and consumption that this is not an arbitrary figure. It is an arbitrary, I should say, it is an arbitrary figure that the staff and the committee have come back with to say, if we were able to get up to, in the first year, $2.5 million, and then up from there up to $3 million, that we can be very ambitious in achieving our goals. But that's not dictated to us.
Right, and various presentations to council and various exercises with the advisory committee included different funding levels for a very comprehensive program, for sort of a trimmed down version. In 08, there was the report contains a table that shows high, medium, and low level of service, and there were sort of like a menu, a selection of what made sense at that time.
And what we're looking at today, just so people understand, is approximately a 270% increase in funding for stormwater improvements over what we have today. And maybe the council and maybe the city and the committee and the staff feel like that's an appropriate level of increase. And my only pushback is to say, let's say we agree to 100% increase or 70% increase. That's still a significant increase over what we're investing today in stormwater infrastructure, stormwater improvements. That surely if we put 270% more funding into it, much of which is coming out of the pockets of our property owners, and we can get a lot done, but why not put 500% more into it, then we get a lot
Yeah.
more done.
Well, and I think that's absolutely a policy decision,
Right.
and maybe a sort of a tangible example is a cost estimate for dealing with a known portion of the system that is of the most older, most vulnerable material. The estimate is $10 million. That could happen at $1 million per year for 10 years. That
Right.
could happen at $2 million for 5
Sure.
years.
Right.
So that's where there's been discussions about how quickly do certain of these program needs need to be tackled. And if we stretch it out, the program cost goes down. But in that meanwhile, some of those corrugated pipes may result in sinkholes or emergencies that we have to then make a decision on the spot about addressing.
Okay, thank you.
May I add something, though, to this? Because another important point that the steering committee made was that they wanted to take advantage of the low cost of interest for both the bonds, to get the bonds as well as to do the construction, so that there is a benefit, long-term benefit financially, to take advantage of this kind of environment, to do this kind of infrastructure investment. And to do it more quickly means that you are spending less overall. So I could see the reason why they were accelerating it, and that was also they were charged with maintaining the bond rating that we value, and I think there's consensus on the council on that. So I just wanted to underline that that was my understanding, and is that
And we've worked closely with the finance office on that issue.
And the other point, I do remember, there was maybe it was the 2 presentations ago, that the rate that we are replacing our pipe, it was going to take over 30 to 40 years to complete the projects at that rate.
For
And
the
again,
section that we've identified as the highest priority.
and that was the 13 miles. And there's still another 40 miles of pipe that is prone to flooding, and that needs to be
And it's made of a
overtime.
higher quality, more durable material, but at some point it
It'll
also will
fail.
have a service
But
life.
overall, it's a $300 million asset that we have that we need to maintain. And the most immediate crisis is the $10 million for the 13 miles, for the old pipe. So, okay, so that sounds, again, that was to get that done quickly, and that will also, if we do this master planning correctly, we may very well discover that we need a lot less hard pipe.
Yeah. And so that program should be reviewed annually so that the priorities and the funding are shifted appropriately and reflect what's being accomplished and what's not being accomplished.
I have a legal question. Maybe City Attorney can respond to that. My understanding is that 6% of the impervious surface is non-profits and churches. Is that
They're tax-exempt parcels make up 6% of the impervious area that is eligible to be divided into the billing units.
Okay. So my question for City Attorney is that under present state enabling legislation, we can say we will not charge those 6% and we'll just collect 94%?
No, sir. In my opinion, you cannot. I think the state enabling legislation is pretty clear about the categories of properties that can be entitled to a partial or whole credit, but it does not authorize an exemption for nonprofit property owners.
Would that be kind of like offering an exemption from water bills? And be in that
I
same
think that's a
category?
fair analogy, yeah.
So you're saying that you have to charge all the properties in the system and not exclude based on any criteria you may have?
Right. There are properties in the city that are subject, I think, to a separate stormwater permit that by law are exempt. And there's a provision that allows you to develop credits for certain other types of properties, which staff will be doing. But those exemptions under state law don't recognize the nonprofit status of a property owner as a consideration that you can take into account.
And the language in the legislation actually uses the term, the fee shall be waived for properties that meet these criteria. So they don't use the term exemption anywhere in the legislation, and then it speaks to the credit scenario. And in response to one of the comments I heard earlier, there's a lot of interest in looking at partnerships where funds through this program can be used to help develop stormwater management facilities in private areas, because in fact, if we had the opportunity, we don't have enough public land to do those types of projects on.
Let me ask one more time in a different way, the same question. Is it possible, again, Craig, I would like to ask you to respond to it. Is it possible the city collect 100% of the fees based on the impervious area and then decide to voluntarily discount back,
Give them a rebate?
rebate certain class of buildings?
That's actually a separate, if you're talking about nonprofit.
Let's say that.
Property owners. There is a separate statute governing donations to certain types of charitable nonprofits. But outside of that, no, I don't think there's the authority for you to provide rebates.
Not rebates.
And we couldn't make donations to churches
No,
for religious
no,
purposes.
that's very clear under the state code provision governing
So
charitable
6%
contributions.
of the impervious surface, we are collecting about $1.6 million through fees. So what would be in dollar terms the 6% will be?
Well, I think we did a calculation. If you take 6% of the available billing units and you apply the current fee rate to it, it's just around just under $110,000. We need to keep in mind that any removal of billable units, that cost needs to be distributed across the other
I'm sorry, that's
parcels.
only $110,000?
That's what I'm trying to find out. That
The rest of us would pay a little bit more to make up for that.
Right, but again, it would have to come down to the legality of excluding properties from the approach that aren't allowed or permitted by the.
What I'm trying to find out, given that it is not a significant amount of money in an overall picture, you're talking about $100,000 out of $2.5 million per year. If there is some way for city to reimburse those nonprofit groups, not as part of this plan, and I'm trying to explore that.
Or could it be a situation where we provide grants to the nonprofits for the retrofitting?
The program currently
And
has
the
a line
churches as
item
well?
for incentives, and part of this follow-up work that would be done is to try to flesh out what those incentive programs could look like and whether they are mini grants or whether they are cost share type approaches. Again, the level of that type of program expense needs to be built into the budget and then has the ripple effect on the rate. But having heard an interest in credits and incentives, that's currently part of the program proposal.
So,
And I would add, I think an ideal would be for us to pursue leverage outside dollars to grow that pot of money or that bucket with which some of that type of incentives, assistance, mini grants could be done. But we need to have a basis or a foundation of a program in order to build those types of opportunities into it.
so if we proceed from the notion that if we as a council say that we value the services that our tax-exempt properties provide to our community, including churches, nonprofits, then how would that, if you were designing a program that included that foundational principle, how would you incorporate that? Is it, for instance, in providing incentives? You said there could be many grants. Now, I heard Mr. Brown say earlier that we can't grant money to congregations.
But in this case, the dollars would go to implement some sort of stormwater management that is consistent with the program
Right.
goals and objectives.
And so, but would that, I'm
Versus
just thinking
a
out
mini
loud
grant
for a
to pay
second.
the
So
fee.
right now, the
Right.
maximum credit is, what, 40%? Is that right?
And that's not set in stone. That was the recommended level. We'd heard some discussions about whether there are mandatory stormwater management facilities on a site versus voluntary stormwater facilities might influence a different credit level. And that's the type of discussion that we need to go through with another informed group and based on the many comments and questions that we fielded through this process. I think I mentioned it before, but in all honesty, that is another significant amount of work, and doing that
And that's the next 10 months
prior
before
to
this
a
goes.
decision about the utility, frankly, was an inappropriate use of time, so.
But I guess
Just
what,
to follow up on Mr. Norris's point, when we were doing CDBG program, we were not allowed to give money to churches, but we could give money to Salvation Army for specific programs like daycare, childcare, as long as it does not relate to religious functions. So in that,
No, sir, that's not correct. I'm sorry, I wish I could say it was,
well,
but
we
it's not.
we have definitely done programs with Salvation Army.
Yes, sir, we have.
But again, legally though, if we had a robust fund to assist in doing the retrofitting, for example, the physical redesign and the physical construction to bring down and drive down their cost burden. Because there's a cost to do the retrofitting, and then there is the simple impact of the fee itself. But just like when you insulate your home, or when you fix your pipes for water, that improves your water conservation and improves your energy conservation, your bills go down.
I think we're getting into discussion.
So, okay, so I just want to get an idea, though, that is what we're talking about, that we could create a fund for to help in terms of providing them with technical assistance and construction
That's within
dollars.
this already, right?
Right, so the question is that over and above what the program currently has budgeted? Is it something that with input from the advisory committee gets evaluated over time, based on, applications to the credit program, based on interest for the incentives?
But if this becomes a goal of the council to do that, it gives you direction that's, but I wanted to make sure that was legal.
Just to clarify, if I could go back to the mayor's point, the city under state law is precluded from making whatever you want to call them, donations, grants, contributions to organizations controlled by churches or sectarian societies. For whatever reason, there are two organizations that would normally be thought of as within that prohibition that are specifically authorized under state code. One is the Salvation Army, and the other is the YMCA.
I want to sort of finish my line of thought from earlier, which is it possible to create a more liberalized incentive program for certain categories of property owners, i.e. tax-exempt properties, churches, et cetera?
I think we would need to circle back with our legal counsel, and it may be similar to the conversation we had about the straight-out qualifying homeowner assistance program, where those approaches might be possible, but they may have to occur outside of the utility.
So I think that's what Mr. Huja was getting at earlier, where if we can isolate $100,000 out of
Yes,
the
that's what I was
$2.6
trying to
million and
reach.
create a separate fund that would then essentially zero out the liability of tax-exempt properties who are taking measures like First Baptist has taken and other congregations are taking or will take to address stormwater issues. So then it's a win-win.
But those are two different things, because I think it sounds like there's already within the fund that this would set up, the latter part of that.
And it
But
wouldn't
to a
be
certain
If
level,
you're talking
though.
about giving money for stormwater projects, I think what Mr. Hooge is talking about is giving them money for social services projects.
No, I was just using as an example for Salvation Army. But what I was trying to find out if there was a way to get the $100,000 back legally, not illegally, but so that we can, if it could be in terms of, as Mr. Norris is saying, stormwater improvement, helping with that, or giving more credits, more than 40% instead of giving 60% or 70%, so they can get some back.
But wouldn't we then be looking at the homeowners and the other businesses that are being assessed this fee and asking them to subsidize a grant to the churches?
I
and
think
the
what it's doing
nonprofits?
is saying that we, as a matter of policy, are not going to pull more funds out of the pockets of social service providers and the faith community in the city, out of respect and appreciation for the contributions they make to the life of our community, and for those that are willing to make stormwater improvements, that we're going to establish a more ambitious program of incentives and credits to where essentially their obligation can be zeroed out. If they don't take any effort, then they won't get any financial.
Since we seem to be in discussion, I would point out that we're already providing free fire service, free police service, free roads, all of the infrastructure of the city that most taxpayers pay for, and our churches and nonprofits do not pay for and get full use of, because we value them for that. And I think that this is something where they're actually getting, this is like water and sewer. It's assessed in a different way because it would be so expensive to measure it gallon for gallon or drop for drop that it would cost everybody more, and I don't think anybody really wants that. But I think that we're looking at a reasonable way of measuring how much people are using of that infrastructure and asking them to pay for it, and that's, to me, different. I think that I'm a member of a church in town, and I'm been on the vestry. I certainly value what congregations do, but I think we also know that the city also provides social services, and to kind of take out of one pot to put in another pot is not, I don't think, really what we're being asked to do.
I was not trying to substitute one for other. I was just trying to explore possibilities. I'm not going as far as Mr. Norris is going to zero out. So I'm still want to link it to drainage improvements.
If you want to put another $100,000 into the ABRT process, I've already supported that.
Yeah, something. No, I was thinking of in terms of actually improvements to drainage on site
And that's already
improvement.
there, yeah.
Is there enough money in there? Is the question.
It depends on how interested property owners would be to pursue it, and I don't know that we can limit that to tax-exempt property applicants,
Right, it would be to
unless
anybody.
going through this
Yeah,
process,
it could be to anybody, but at least if there is the money, non-profits will also have an option to do that.
Well, I think we'll need to go through this follow-up exercise of further expanding what those credits and incentives look like, and then take into consideration whether there should be modifications to those funding levels in future program years.
Yes, understood.
Can I ask a question?
Yes, please.
And I'm going to go farther back, because one of the criticisms that we've gotten since our last meeting is that only a user fee was considered. And I wondered if, as part of the initial conversations way back when, that the user fee was determined to be more fair and equitable than raising the real estate tax, if that analysis was done.
Probably the best answer is that subsequent to reports and presentations to the sitting elected body at that time, we were directed to continue down the path focusing on a utility as the approach. In each case, there is a program cost that's been put out there, and that lends itself to the opportunity to identify the tax increase that would be needed to accomplish that, or the hybrid approach. So if at any time in that process we had been directed to pursue that route, then we would have pursued that route. And I think it's been asked a number of times now what that looks like over several years, and if there's more information you need, you can look at.
I mean, I did look a little bit at that, and it's kind of all over the map, but what you do see a general trend is that the user fee is more fair and equitable because the very large, particularly shopping centers, have disproportionate amount of parking lot. It's really a parking lot issue. So to use a real estate versus a user fee kind of puts more of the burden on the residential communities for these large parking lots. But there's a variety of ways to look at it, and I just wonder if that other than my little Excel sheet had determined that. One thing that I just wanted to point out is in compliment to the conversation that we had, and I'm a little sorry we didn't hear more of this in public comment, but there's lots of conversation about how you all want us to fund things, but we are the taxpayer. We represent the city taxpayer. And in fact, some of the statistics we got is the city taxpayer already subsidizes the churches and nonprofits, most of which are churches, more than 80% of this group, that's tax exempt fee eligible, are churches, by $1 million a year. The city taxpayer is already subsidizing. And that's not to say that anybody doesn't want to subsidize, but let's do recognize that we do contribute a lot. And so, that said, I was sort of shocked.
Can you explain what you mean by we're subsidizing them by $1 million a year?
Because that's $1 million a year is what is not paid in taxes. And so therefore, our budget, which is funded with taxpayer dollars, it compensates for the fact that $1 million, and perhaps you can argue that that's the wrong word, and I'll retract it. But
because their properties aren't taxed, the other taxpayers
That's
pay
a
more.
foregone opportunity.
And the property value, tax value is around $1 million. It's actually a little more than that. That said, I was shocked to find out that the contribution from what is mostly the churches was as low as it is. And so it is a bit of a shame that we're fussing about this over what is really quite kind of a small fraction. That said, the user fee really is the most fair and equitable if we're walking. So we're really in a quandary here, is that, if real estate taxes were really even an equal basis with user fee, I think it would be easier to deal with this. But the impact on the residential user or residential taxpayer would get double hit if we were to adjust it just in order to avoid this requirement that we put this user fee on churches. The other just interesting observation that I've had is that we have heard mostly from the First Baptist and First Presbyterian, but mostly from First Baptist, which I don't think is any surprise because the First Baptist Church is by many magnitudes the largest and will have the greatest fee because it's got the most impervious surface. It's 16 acres almost in the city. I mean, it's in a lot of that parking lot. So so in order to, as we're talking about giving back money to churches, that's the little church in the middle of a neighborhood that really probably doesn't even have land to mitigate its stormwater. It just starts getting really messy, I think.
As we make comments and suggestions, I would hope that we can come to some conclusions also by the end of the night at least. And my hope is that if you have some ideas for amendments, you may want to suggest those now as we go along so that we can come to some conclusion.
I'd like to propose the same thing that Ms. Galvin proposed last time, is that some of these issues that we're discussing are things that really, I think, can be put into place in the next 10 months. I think if we have an ordinance that we can start working out some of those things, and if we want to give some guidance to staff or to to that process, to that committee, it would probably be a good time to do that. But I think that I'm not sure that we need to resolve all those things before we pass this ordinance.
Well, and I think tonight...
It does affect the ordinance eventually.
Well, so does, what percentage is available in credits and how the system gets set up for people who are low income and need help paying this fee. And those are things that we have directed staff that we want to be considered in the next 10 months. And this doesn't go into effect until January 2014.
Well, I do want to just say, it does sound like we are reaching agreement on the value of the utility, the user fee, as opposed to the real estate property tax revenue. And it's because the equity issues that, of the fairness that Ms. Smith has brought up, but I also think that just like the utility water or sewer that like Ms. Akos brought up, this is something that through changes in consumption, you can bring your user fee down. And that's very, very important for the environmental aspects of this, that we will actually change the landscape by making it, by incentivizing the property owner to change the impervious surface. And without that utility aspect, there is no incentive, there's no compunction to change. And so that's a really important piece. I just didn't want that to get lost. And then the only thing I wanted to make sure that I understood, and it was in section 10-105, under the stormwater utility fee credits, it says that the city council shall adopt by resolution a system of credits in accordance with Virginia code that provide for full or partial waivers of charges to any person who installs.
Right.
Does the person include organizations, corporate entities?
Churches.
I don't want to exclude our churches and our nonprofit organizations.
Any
It
property
would
owner?
include
I would
any
have to check, but I
property
think
owner
it's
in-
the person receiving the bill. So
Yeah.
in that
You
case.
could not discriminate against a church or other
Could we call that
nonprofit in
any
that
property
context.
owner rather than any person?
That would be the only thing that I caught in the language itself that was a little troubling.
I think you have to think carefully. There is only property owners. There are maybe leaseholders, maybe.
It may actually also try to expand the opportunity for creative off-site type of strategies that a person funds on behalf of a parcel. So I think it could get really complicated. I imagine that that word is intended to build flexibility into the type
Can a
of credit.
person be, does that include a corporate person?
Yes.
It does,
Supreme
okay.
Court has ruled so.
So it'll be in our minutes that reflects
we
a corporate
want-
person, just in
okay.
case.
I have another question I want the Commission, the Council to think about. We had talked a few meetings back, the idea of a sunset clause, maybe 10-year sunset clause, so that we can see how things go and so there's some incentives to evaluate it in a meaningful manner.
Should we set a reevaluation when the bonds are paid off? Because I think we're obligated to keep it until then. right?
And that was also the reason why we made the resolution about the advisory committee, because we felt that that was very much within their purview to make that kind of a call, and that was why they're going to be routinely evaluating the program and the funding needs. But we couldn't
Sunset
anticipate.
clause can help you think harder. Because if
Like
you're,
sequestration.
I won't go that far. Other suggestions and comments?
Well, I just had, sort of going back to square one question with Mr. Brown. Can you educate us as to why the Virginia Constitution does not allow localities to levy real estate taxes on churches and congregations?
I don't know that I'm qualified to answer that question. I can verify that's what the Constitution says.
And could you hazard a guess as to why it is that churches are exempted from real estate property taxes?
Well, you've heard comments about separation of church and state. You've heard comments about recognition of the role that churches play in our society.
When the Congress shall make no law.
Yeah, I think those are all valid observations.
So we can require a church to pay a water bill if they're using water,
right,
or electricity bill if they're using electricity. They don't have a choice as to whether or not rain falls on their property or not.
But they do have a choice whether that water goes into our system.
They are still having to pay the fee, even if they capture 100% of the water on site. As I understand it, correct me if I'm wrong, Mr. Erdogan, but they're still going to have to pay a fee.
Well, if they didn't have any buildings or parking lots, they wouldn't. In other words, they have a choice of how much they're putting on the property.
Well, again, I think that's.
I mean, if you're just being theoretical, of course it's absurd. But
Right.
but I think that it it's under someone's control what they put on their property, and what they put on their property is what affects how much stormwater runs off of their property.
And the way the ordinance does read is it does allow for full or partial waivers of charges based on these credits. So we're still not, we could go up to 80% of a credit. We
That's
haven't.
the question I was
Although the rate
We
might have to
haven't,
go up.
but that hasn't been settled yet.
It hasn't, and I think that's the exercise we need to go through with these other, with another group of folks to ensure that there's consistent understanding of what the goals and intentions of the credit program are with respect to this program, what the program costs are, how that's affected by very aggressive or very comprehensive credit programs. Again, keep in mind there are some communities that have no credit program, and there are some that have a very sort of token credit program. And I think we need to take the conversations we've heard and use that to inform the discussion. In many cases, the fee and the credit is proportional to the program costs and the type of areas the type of the program elements that program will be funding. And so zeroing out the fee for many properties has a serious impact on how the program is structured. And
I have a question. When you're talking about credits, credit means that you have to pay less for the same amount of impervious
Right,
surface.
so
because you've
essentially,
done
like, yeah, the
something else.
simplified
But
version
let me
is-
just finish, but so if you replaced your parking lot with pervious pavers, you would be paying less, but that wouldn't be your credit. That would be in addition to the credit. You would be paying on less acreage.
So if your parcel has 10,000 square feet of impervious surface, and you either convert 2,000 square feet of that to something that manages stormwater, or rip out parking lot as a simple example, the area, either the calculation is based on that reduced square
Right.
footage of impervious surface, or it would be based on the area served by the facility that's either reducing peak flow or pollutant reduction. So,
Or both.
right, but it isn't, if you have a 100,000 square foot property and a teeny little pond in one little corner that's serving the grassy turf area in front of the building, that 40% or whatever percent wouldn't apply to the entire fee, because it's not performing that measurable service that's reducing by extension the program costs to treat runoff from that type of a developed parcel.
I guess my question is that even if we were to limit it, and we're not doing it tonight, but just to kind of conceptualize for myself, that if we were to limit the credits you could get to 40% of your bill, you could go beyond that by reducing the amount of pervious surface on your property.
Correct.
So it could go beyond
Right,
that 40%.
correct. And there
Okay,
may
that's a good
be
dis-
properties
that's a
for
good
whom
point to
it is
make.
more cost effective to reduce impervious surface than it is
Or you could
to
do both.
install.
I must say I dislike the use of 40% repeatedly, because I would like to see it much more than 40%. If it's incentivizing at least minimum 50% or 60% in that range before you will have incentive to do anything.
We have to be a little careful, because the more we allow credits for those who have the resources to put in these mechanisms, the more those people who don't have resources and are kind of stuck, they might be in a rental property, they might just be low income, and they they're going to have to pay more. And this is the same dilemma we have with water. The more we all conserve, those who aren't able to conserve, their rates go up. And it's just a very, I think we have to be really cognizant, and I think we take the amount of impervious surface a little bit too literally, too. I mean, I sort of see it as a relative measure, too, of contribution, as opposed to saying this property has this much impervious surface, so it's going to contribute exactly the same amount as that property on the other side of town that has the same amount of impervious surface. We need some measure of contribution. So I'd be cautious about taking too literally, really exactly how much one property.
We have had a fair amount of discussion on the topic. I wonder if there's a motion on the floor which you can debate.
I'll make a motion that the ordinance, or that, is it an ordinance? It is, right? And policy as written, that we pass that.
Can I do?
Let's wait for see if there's
I'll make a
second.
motion that we adopt this ordinance
Is there a second, is there a second to the motion?
I'll second the motion.
Okay, discussion.
But I do have a question where it, in section 10-105A, where it says to provide full or partial waivers, did we mean to say that?
That's the language that's
State
in
law
the
says-
enabling legislation.
Oh, that's in the
Yes.
enabling
And so-
legislation, okay.
So
But I
again,
think we
it
need that
provides the
flexibility.
context within which our credit program would be developed.
And I would just,
don't, Ms. Rittervold can correct me, I don't think the 40% is in this ordinance.
No, it's not.
And we've asked
That's-
the
And we've asked
No,
committee to kind of look at
again, that may
what's
be
reasonable.
something that over time evolves, and we didn't want to have to change the ordinance with each consideration of adjusting that credit program.
What is the length of bonds you're thinking of getting? Is it 10 years, 5 years, 15 years?
They're 20-year bonds.
It's 20-year bonds.
I would really like to see a sunset clause, if that 20 years may be logical, because it's 20-year bond.
Mr. Huja, I had presented a clause that said that, that we would allow for it to be sunsetted upon conditions being met, but not a specific set of time, because we did
So
not
what
know.
conditions- what-
And those
what might be?
conditions were the meeting the TMDL requirements and then replacing the stormwater lines as required.
Which is language that's included in the resolution for the advisory
For the-
committee to help
And that
guide.
was embedded in the advisory committee.
And there would be, there wouldn't just be a single bond sale over the course of those 20 years. So there's also a staggered effect of when bonds are sold and when the debt payments are made.
Is there, at any point that this rate goes up or down, it has to come to council, I assume?
It would absolutely come to
So
council on an
another
annual
way
basis.
to, yeah, to
On an
handle,
annual
yeah,
basis.
on an annual basis,
Yes.
it's coming to
Yeah.
council in
Yeah.
any case, so
Yeah.
it's, I don't, that's not really a sunset clause, but it allows the same sort of.
Is there further discussion on this motion?
Yeah, well,
Yes.
I'd like to, again, propose, and I actually, Kathy referred to it, just another way to compensate not only the nonprofits and churches, but sort of all of our citizens. And let's remember, we have a very large proportion of our population that is low income. And this is tough on them as well. That we do consider using a balance of the same amount of money that we are imposing on the whole system to lower our water bills through in what I would propose through the payment in lieu of taxes, which happens to be exactly the same amount of money.
But not
So
tonight.
therefore, you get lower water
But
bills.
that's going to be a discussion in April. right?
Yeah, it would be April, but just to propose that is another way of compensating.
Well, you
the
can
burden
propose that in
of
April,
this.
budget time.
But not as part of this
No.
motion. Is
But-
that right?
No,
Okay.
no, not
But
as
I
part,
appreciate
because I
what
don't
Ms.
think
Smith
we
is
can.
saying, that we have to look at the whole burden.
Are there other suggestions for changes to the
I do want to get some feel about the advisory committee.
That's the
and-
resolution, which
Okay,
isn't
we haven't
on the table
discussed that yet.
so That's the next, you can.
But I
make
just
that
wanted to make
motion
sure
with-
that as we're moving forward, that we do bring in, yeah, I guess it is that discussion, okay.
Another thing which appeal is to the staff only. I wonder why this appeal is not to the advisory committee.
Oh, we went through that before, that was.
I'd like to hear it again.
Can you explain exactly what it is you're talking about?
I don't know the exact section, but
Oh,
appeal
with
is to
the-
the.
Appeal.
Oh, Peel.
Appeal.
Okay.
It's section 10-108.
You have the authority to set up boards or commissions or task forces to advise you on matters that are pertinent to the city's affairs. If they're empowered to make binding decisions.
No, I'm not saying that.
I think we
Okay.
actually changed that language to do it through staff because it was less onerous than doing a more drawn-out process,
And plus, we couldn't use
to
advisory.
make it
Well,
as
we
simple as
usually
possible.
use some kind of board or commission for appeals for our real estate taxes.
And
The
that's
citizens-
authorized by law, that there's a board of equalization that we're required to have. Are you suggesting that they would just make an advisory ruling?
Yeah, that's all.
Okay.
Well, I mean, we could look at that. I think it's the mechanics of when the bills go out, when the payment is due, when that credit is then applied to the next bill. If the committee is meeting on a 3 times a year basis, it may be a timing issue of I mean, we can look at it.
And it can be appealed to circuit court.
Correct.
The reason why I'm saying this is that Public Works will be making the decisions. They'll be the provider of the service, and an appeal will be going to the same body. And it seems somewhat.
If I could ask, Mr. Mayor, who would the advisory committee be advising?
The Director of Public Works.
So right
I mean,
now.
that could be a role of the advisory committee. I guess this is one disadvantage of doing this for the first time, is that you don't know if you're going to get one appeal or 100 appeals.
And you might also consider modifying the duties of the advisory committee based on how appeals are handled and whether that's satisfactory in the first go-around.
Can we make an item H under appeals, saying this structure for doing appeals will be reassessed at the end of the first year for modification, for potential modification? Would that get at some of this? So we could do it for a year and say, this seems to be working pretty well, let's just keep it up, or we need to change the way that the committee becomes a board of appeal? It seems hard to tell from this point if we really need to add that extra layer.
It just seems to me that you are, I don't want to use the word conflict of interest, but there ought to be some kind of checks and balances, that's what I was trying to say.
And that might be a check to examine that at the end of the year.
It could be. Any other suggestions for changes?
Is this is also room, opportunity for discussion on the motion?
For sure, the motion, yes.
Okay. So I want to go on record once again as indicating my opposition to this proposal. I won't rehash all the reasons I brought up in the past, but I do think the level of funding that it will affect is it's at a time of tough fiscal choices. The idea that we are asking the schools to make pretty significant cuts in their budget. We are holding the line on other services, and yet we're about to increase funding for stormwater improvements by 270%. And I think that troubles me. I do think it is not a good time to be pulling more money out of the pockets of our property owners. And it will be putting our city businesses at a competitive disadvantage to businesses in Albemarle County, or other counties for that matter, because they will have to pay this fee, and in many cases, or in some cases, it will be a fairly substantial fee, whereas businesses right across the line will not. I'm very troubled by the fact that it is impacting our tax-exempt properties, particularly our congregations. There's a very good reason why the Virginia Constitution does not allow us to levy property taxes on congregations. And I think the examples that Ms. Sakis brought up about, we don't charge them for fire service, we don't charge them for police service. To me, we also don't charge them for repairing the sewer system, well, the sewer is different because they do pay a sewer bill, but we don't charge them for the stormwater system because it is not a user fee. You're not paying to use that rainwater that's falling on your property. To me, it's much more equivalent to the fire service or the police service. And I'm very troubled by the implication. And it disturbs me that we're about to take a good bit of money out of the pockets of nonprofits and congregations that are providing so many valuable services to our community. I would like to see us continue this methodical increases that we've made in our general fund for stormwater improvements, continue some of the other approaches that we've taken, look at more stronger incentives without enacting this new tax. Having said all that, I realize I'm in the minority there. I would like to at least see if there's support on council for directing staff to come back with, given the fact that the state enabling legislation for the stormwater utility does allow for the possibility of a full waiver of charges, that we direct staff to come back with a proposed credit/incentive system that would allow for a full waiver for tax-exempt properties that are taking steps to remediate stormwater impacts on their properties.
I would just like to kind of speak to one of the points that you made toward the end, which when you're talking about the need to find money for schools and other critical things that we need as a city that are part of our core services. And to me, that's the very reason that I do support this fee. I think that if we continue to take, we're required to do a certain amount, we're required to have certain outcomes to our stormwater drainage by federal law, by the EPA, by court rulings. And I think if we continue to pay for that out of general funds, that what happens is we will suck our other services dry. And I think that that's not acceptable. So I would much rather have this be more of a fee for service and put it to the side so that we can concentrate on providing those things that there are our other core services, because this has continued to grow through no fault of our own. It's not something that we have changed the regulations, and that's why it's suddenly costing so much more. I think that these are things that have come from, from regulations, and I think they're actually good regulations, things that protect the environment, things that make it possible for human beings to live on Earth a little bit longer. But to be able to continue to bring that out of our general fund, I think is an unsustainable model.
I would just like to say, and thank you for both comments. I think there's a very rich discussion. I do want to underline that I don't think of this as a tax. I think of it as a user fee, a utility. It is very similar to water and sewer and electricity. The infrastructure underground is something we don't see. It's what the city pays for. It's very, very important piece of infrastructure to contain and to control and guide stormwater. That said, in this case, we also have the ability to pinpoint the contributor, and it is impervious surface, and it is a function of the amount of impervious surface that is related to the user fee. That property owner has the ability to change that rate, not the rate, but the amount that they pay through the changes they make to their property. So again, it's very much like all the other utilities. You conserve, you lower your costs. You change the dynamics on your site, you lower your costs. It is a utility. It's a user fee. It is not a tax. A tax is something that's levied across the board, indiscriminate to what it's going to be used for. It gets put into a general fund that then is subject to the vagaries of every year's different discussions on council. It is not dedicated. It is not long-term. It will not solve the chronic problem we have with our pipes, and it will not deal with the new regulations. So I want to be very clear. I do not view this as a tax. Now, saying that, I do extremely value the partnerships that we've cultivated over the years with our nonprofits and our religious organizations. I do support Mr. Norris's idea. I kind of floated it earlier that we would be thinking and working with our partners to assist them in driving down the cost of this user fee. And it's very much in keeping with how we want to work with our low-income property owners, but because they have an assessed value, they have property, they have taxes they're already paying, we have a model for that. We don't have a model for the nonprofits and the churches. That's why we need to do this slightly differently. So I am support. I don't know what that mechanism is exactly, if it's a grant program, technical assistance, something that will acknowledge the good work that our religious community and nonprofits are doing. But it is a very fair fee, a very fair approach.
Ms. Smith, would you like to make some concluding comments?
Yeah, I'd just like to say that the reason I favor this is because I do think it's more fair and equitable, and I love the concept that we would actually have a tax, and it is, I think, I'm not afraid to call it a tax, but that is fair and equitable, but with I'm going to push hard when we talk about utilities to compensate it compensate not only our churches and nonprofits, but all of our residents, with a particular eye on our low-income residents, to balance it out by taking away an extremely regressive tax. The pilot is just about as regressive as you can get. And the idea of sort of trading this fair and equitable way of assessing our residents by taking away something that really should never have been is, to me, an incredibly attractive idea. But fundamentally, I do believe this is the most fair and equitable way to pay for this very important environmental project.
I want to make a few comments also. First of all, I want to say that this is an important effort on part of the city and for the whole community in terms of the environmental quality of our water. It is, we lose sight of that sometimes, but as Chesapeake Bay is involved, and so we need to improve the quality of water, and I think it'll help our environment. Secondly, I think it is a fair way to deal with the important need of our community. And I would also support the resolution as presented. I also want staff to explore what Mr. Norris said. If we can minimize the expenses for people, we have to try to do that, and I would like to see that happen. Similarly, in line of credits, I would like to see credits to be much higher than 40% so that we can reduce the expenses for people, especially nonprofit groups. Any other comments? If not, this is the first and second reading. We need to vote.
This is the second, yeah.
Again, I want to thank our staff also for
Well, we have a resolution
good
as well.
work. Resolution also we need to discuss?
Did you want to make an amendment to the resolution, or?
I just wanted a discussion a little bit about the makeup of the committee.
Do you want to make the motion and then?
And I may not need to, just when you say representatives of local
But we need a
institutions-
motion to adopt the resolution.
Oh, but I want to.
And I'm happy to do it. But, okay, that's fine. I
That's
just
what I'm
wondered if you
asking
wanted to
for.
do it as part
I
of
don't
it.
see the resolution. Where is the resolution?
Establishing a stormwater.
I wanna
utility.
just
Isn't it-
make
Aren't these
sure-
two different decisions? Yeah.
Yes.
That, again, when we talk about local institutions and service agencies, can we make sure that we are bringing in the church communities and the nonprofits? Is that implicit in this, or do we need to be more explicit? And if so, then I'll make a motion, but I do want to make sure that we have that representation.
Mr. Brown, maybe you can correct me if I'm wrong,
This
but
will be
the process.
a council-appointed
A
committee,
council-appointed committee,
you can-
So we
there
have-
will be an enrollment period or an application
Okay.
period, and then there would be the opportunity to look
Okay.
at who's in that position.
On that end, I would like to see if council would agree to, I think I did this last meeting for something else, to say at least 7 members, because I think we might find ourselves needing representation. Is it 7
It's
members?
7.
I think it's set at 7, but if you-
Yeah, I mean,
I'm all
that gives
for
us
at
some-
least.
Yeah,
Yeah.
it
At
gives
least,
us
yeah.
some flexibility.
Do you want to
I think that's a good
entertain a
idea.
cap? Because at some
But we,
point,
yeah,
committee
but not,
becomes.
not to exceed,
Yeah, it
certainly
can be
don't
some
want more than
self-
Say
15.
at least 7, and then we can decide.
No more
Or
than
7 to
12.
10 members, or?
Or you could just see
Seven to-
who's
Even
who
I
expresses
would go-
interest and make the
Yeah.
decision.
I was wondering if in the resolution you will be willing to add advisory committee being advisor to the director on appeals.
Well, that's
think
not
that-
in the ordinance that we just passed.
No, I'm talking about
so-
the resolution now. I'm talking about resolution. Where the advisory committee is.
But I'm not sure we can change something in the resolution that isn't in the ordinance.
There's nothing in the
No, advisory
ordinance
committee is
that-
totally separate from
I understand that.
ordinance.
But if
But
the
the
appeals
ordinance,
process has
yeah.
already been set by the ordinance.
Right, you
That
can't-
would be changing the appeals process without changing the ordinance.
I really think there ought to be some impartial body to do the appeals.
I think we have to think too about, what this advisory committee is going to do. I would like to suggest that the advisory committee take a role in researching and discussing the credits. And to that end, would hope that the advisory committee would have some of the amazing expertise we heard at our public hearing. we have a lot of professionals in this community that know a lot about stormwater
Yeah, and
management.
I wonder if you would be open to, again, a stakeholder group that's convened to look at the credit policy, but that group isn't necessarily the advisory committee, since the advisory committee is to speak to a broader set of issues in the program. Some of those may be the same people.
Right, I see.
And some of them, it would be very helpful to tap ideas and comments and questions that have come in. And, you know, maybe that process includes some additional public input.
Well,
we
that would
can work
allow
through.
us to get up to a bigger group,
Right.
too.
And that would also be important, and that's fine. I think that's a great idea. But I would hope it would get formed sooner, so that we can, obviously, if credits are being developed this year,
Yeah.
that
I
we'll
think
need
we'd
to
have
have to.
Well, in a way, it's a task
So
force.
would it, perhaps the duties of the advisory committee shall be as follows: during, you know, before the onset of the actual fee, to help create, or to help advise on matters of credits and policy, to convene a stakeholder group.
Yes.
Would that be?
I guess that we just need clarification on whether this advisory committee is also part of the development of these policies that we need to bring forward.
And that's what we talked about last meeting, that we thought they should be, but that's.
Why do you need two different committees? I just wonder.
Well, if you're really looking for expertise
Right, I
with
mean,
the
there's some
credits.
pretty specialized expertise
Yeah.
to consider credits and incentives versus program priorities and some of the bigger policy decisions that committee would be monitoring,
How about to
tracking,
review
compliance.
How about
policies?
we
or-
could-
I mean, certainly, that's one of the policies.
There needs to be another set of eyes.
Right,
The
but I-
duties of the
Yeah.
advisory committee shall be as follows: to work in concert with a council-appointed task force to establish equitable credit structure, something like that.
Why
They-
not just
Will we get a
Why do we need
credit
another committee?
thing
We don't
back
task
here?
force.
No, but that's what that's the
No,
stakeholders.
You don't need
No,
a-
that's one meeting.
That would just be one meeting? You think that could be done in one
No,
meeting?
No, that's
this-
not what
I guess
they're doing.
I guess what we're anticipating is that the credit policies would be developed, as you had mentioned, in the next 10 months, so that there's something defined for the first year, and that this committee,
advisory committee could do that?
that the committee would review that and see whether adjustments are
Developed
needed
by
in future years.
Staff? Is that-
With input from,
With
you
input
know,
from-
subject
Okay.
matter experts
And a
or.
stakeholder group meeting and various other.
Right, but the configuration of that committee that helps work through the credits doesn't necessarily imply that they are the advisory committee moving forward, if that makes sense.
Would it also make sense then, because in the resolution says the initial appointments will be made effective January 1st, 2014, to speed that up, to appoint
Now.
this committee much sooner?
Yes.
But again, I think it depends whether that full committee needs to be there to work through the credit policy pieces, or if that can be done with a task force or an interim group of expertise.
Well, this says that we want a group with city homeowners, representatives of the business community, representatives of local institutions and service agencies, and individual technical expertise and interest in stormwater management. So it sounds like you may have in this group.
Yeah, I think.
I mean, I think that you
people
would
who could
have
advise
people
on
who
those
are going to
things.
want to be on the advisory
Yeah.
committee, but you may have people who want to participate in just that piece, the credit policy development, but don't want to take on the commitment of
The entire-
the time period commitment
Well, and you-
associated with.
And you could have a subcommittee that would be part of
I
this
really
group
don't
that
see the
could
point of having
utilize
two
some
committees.
outside
Right.
expertise as well, so.
Right, so maybe this resolution proposes subcommittees can be established as needed to support the program and advise the advisory committee or assist the advisory committee, if that,
And they can call on the expertise of others as needed.
Right.
you know,
which I would
whatever.
hope they would do.
Yeah.
Right.
I assume so.
Let me make one more try, so that I will give up after this one.
Okay.
I really think that appeal process should be other than staff. Should be decided by other than the staff. It will make the applicants more comfortable because it will be less perceived conflict. And so I really think that there ought to be, appeals should go to the citizen body and then the staff.
And I think that we already had somewhat sense of council that we would make that decision at the end of the first year. Is that?
And I would think the biggest conflicts would come with disagreements over credits.
Yes.
Because you would
Or
think
over
the
how much
impervious.
pervious surface you have.
You know, it sounds like they're going to get a pretty.
Appeals, you're right.
Yeah, I mean, I really appreciate they're going to get a snapshot.
Or,
I don't know, Mr. Herndon might
or
be
appeal
providing
go
that.
to, or appeal go to after the staff directed to the advisory committee, or something of that nature. So there's some, before you jump, you're forced to jump into court, you can go to some citizen body before you go to court.
I think it's a good idea. I'm not sure we need to do it right now, but I actually think it's a good idea. It's, as we say, we're not, I would bet the appeal process, which I do think will fall into two different camps, is going to be the greatest in the beginning.
Yeah.
I mean, until
Yeah,
we
and
get
I mean,
all
I
the
think
kinks
that
out
at
of
that
it.
point,
Yeah.
there's going to be some housekeeping that happens with that first round. And
Yeah.
Okay.
Obligating an advisory committee
If
to
there is no
engage
support for
may
that
not make
idea-
sense the first year.
If there's no support for this idea, is there any other discussion? If not,
I support you on that, Mr. Hooja, just for the record.
I need 3 votes.
Especially one
And
who's
I
voting
I
for the
think I
resolution.
will ultimately, but I
Vote for
really
this
think
one.
we need to get a little
focus on
farther
setting the
along.
program.
Was there a
up
maximum number of committee members? I said there was at least 7, but was there a
Well,
maximum
Seven
number?
to nine.
I'll make the motion, and I would, how about if I try with between 7 and 10?
You want odd numbers, you don't want even numbers. on the
Between
committee.
7 and 9.
11, 7 and 11.
7 and 11?
And with
I don't
some
care.
Slurpees.
I go for
Yeah.
13.
7, 11, it kind of rhymes. Is that the middle range between 9 and 13?
Okay,
7,
I think
11.
it's good. It's,
Okay, sold.
Okay, is there a motion on that?
I second.
Okay.
Because
Any
this is an
discussion on the
amendment.
motion?
This is an amendment. We're voting